At 10:01 a.m. This is the public meeting of the Real Estate Commission.
So selection of leadership is on their agenda today. So because we don't have a designated chair yet, I'm going to just kind of walk them through the agenda first. So I will start off with a roll call. Tom Patton.
Here.
Bernadette Lugerin.
Here.
Erica Sanders.
Here.
Erica Doyle.
Here.
Autumn Rubal.
I'm here.
You have a quorum. So next up on your agenda, commissioners, well, before we go into the approval of the meeting minutes, let's welcome Tom. Tom is now the broker that has significant experience in property management. Would you like to say some things about yourself, Tom, to introduce yourself?
Well, I have a small property management company. I'm also a commercial broker. So, my company's name is Strategic Partners. Mickey Sanders is the one who recommended me. I don't know, it seems like most people know Mickey. So, yeah, it's an honor to be here. I appreciate the opportunity.
And why don't we go through and just kind of do an introduction? Because this is actually the first time our commissioners have gotten to meet us in person. I'm Marcia Waters. I'm the division director.
I'm David Donnelly. I'm the manager of the Education, Communications, and Policy Program.
Bernadette, do you want to?
Yep.
Let everybody know what seat you fill?
Yep. So my name is Bernadette Buchanan. I am a commissioner in the unlicensed agent spot, just for the public, as a commissioner.
And I am Erica Sanders. I sit in as actually right now vice chair of the commission, which is I also sit as a licensed broker.
I'm Erica Doyle. I sit as a licensed broker on the commission, and I am from Grand Junction, so I would like to welcome everybody to my neck of the woods here. And thank you everybody that is here in person, so.
Thank you for having us. I'm Sarah Halloran. I'm the deputy director.
I'm Penny Elder. I'm the expedited settlement program manager for the division.
And Dina Groni from the Attorney General's office. I'm a general counsel to the commission.
And my name is Eddie Rose, and I'm one of the investigative team leaders.
And we do really want to thank the Grand Junction Area Association, Realtor Association, sorry, I have not had enough caffeine this morning. For hosting not only this meeting, but they're also hosting the Board of Real Estate Appraisers tomorrow. So we're glad to be here. And just so everybody's aware, we plan on doing like a road show every year in a different location. So we haven't picked locations yet for next year. But maybe it will be the northwestern part of the states for the Real Estate Commission. We also have Board of Real Estate Appraisers and Board of Mortgage Loan Originators to kind of schedule as well. So thank you guys for being here. With that, up next is the approval of your April 7th, 2026 Real Estate Commission meeting minutes. Does anybody have a motion to adopt those?
Motion to accept our meeting minutes.
Second.
You've got a motion and a second. Is there any discussion? Okay, how about a vote? For all those in favor, say aye.
Aye.
Any opposed, say nay? Okay, the ayes have it. Those are adopted. Next up is public presentation.
We
of
did
issues-
have Autumn online.
Yes,
Oh,
I did hear her. She said aye.
But
No,
Yeah.
it was an introduction.
Oh, I'm sorry.
It's all right, out of sight, out of mind. I apologize, guys, that I couldn't be there in person. I have a pretty big meeting with a client tomorrow that required me to be in Denver, but I'm Autumn Rubal. I am a public commissioner, and I think I'm on year, well, 2.5. I'm 2.5 years in, so it's nice to meet you.
Sorry about that, Autumn.
So can we have
No problem.
You have paper copies?
Yes.
Okay, so next up is public presentation of items not on today's agenda. And that's an opportunity for any of you to speak to the commission. And then also if there's somebody online that wants to address the commission, please use the raise hand icon and David will unmute you.
So if anyone from the public here would like to address the commission, please just raise your hand and we can identify you. And then also similarly for anyone that is online, if you'd like to select that raise hand icon out of the Zoom platform menu, you can please do that and we can do that. We can just give it a moment here, commissioners. However, I'm not seeing any.
Okay. So we will move on to policy matters, and item A is selection of leadership. So you need to choose a chair and a vice chair.
I'd like to, just say that Eric Sanders has been doing an excellent job of vice chair, and so I would go ahead and motion that you take on the chair. I appreciate that. Thank you.
I would also like to nominate Erica Sanders as well.
So I can make a motion. I will motion that Erica Sanders take it to the chair.
Okay, so there's a motion. Is there a second?
I'll
Second.
Haha.
There's a motion and a second. Any discussion? All those in favor say aye.
Aye.
Any opposed, say nay. Okay, that motion passes. Erica? You're gonna take over the meeting in a minute?
Okay, well,
Okay.
thank you so very much. I appreciate the nomination and bear with me the first meeting as I try to get through motions and everything, but thank you.
So now you need to nominate a vice chair.
Well, and not to complicate things, but Erica, the other Erica, I think has also, I mean, everyone's done a really great job. I think you bring a lot of knowledge, a lot of for preparation to the board, and so I think you would be great as vice chair. And you also have been here for a while as well, so that would be my nomination.
Is that a motion?
I motion, well, I didn't, yeah, I'll motion to nominate Erica Doyle as vice chair.
I will second that.
Okay, so there's a motion and a second. Any discussion? All those in favor say aye.
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 All those opposed say nay. The ayes have it. So the two Ericas are now in control with Erica Sanders running the meeting now. Although it is policy matters, which is still me. So, commissioners, you had requested that two items addressed at your public comment session in the April meeting be added to your agenda for today. The first one is the title insurance disclosure raised by Gary Wolf. I have forwarded you several different email correspondence from him. So it is up for your discussion.
I have some notes on this one. I can start. I would only speak for myself at this juncture. I'd like to thank Mr. Wolf for his submissions over the years that I have been here. I have in fact reviewed his information every time it's been submitted. I've additionally read the information during the review of the proposed new forms. It was removed at that time. In my recollection, it was determined unanimously that the new form wasn't warranted for a variety of reasons. I've heard the presentation, the public presentation of issues at the last meeting, so we further reviewed the comments for this meeting. I believe the purchase contract covers this and that there is transparency for consumers and specifically about title insurance. Several years ago, clarity about who purchases and where the title insurance is purchased was added to the purchase contracts by separating these options out in 8.11 and 8.12. That either the buyer or the seller can purchase the title insurance and then they can specifically direct where it is purchased. This is fully negotiable. Further, in the exclusive right to buy and the exclusive right to sell, we have an entire section, section 16, in the exclusive right to buy and section 22 in the exclusive right to sell, that is dedicated to telling buyers and sellers that they should shop around. I want to read this to everyone as I believe this is the crux of Mr. Wolf's issue, and I want to make sure he's aware we have this in place to assist consumers at the division, the commission, and as a practitioner, I believe we all feel it is an important disclosure. So 16, disclosure of settlement service costs. Buyer acknowledges that costs, quality, and extent of service vary between different settlement service providers, example, attorneys, lenders, inspectors, and title companies. Broker cannot require buyer to use a certain settlement service provider, and buyer can shop and select similar services from other companies. Buyer is ultimately responsible for selecting, qualifying, and paying for settlement service providers who provide services to buyer. So as such, after multiple reviews of this request and information, I don't personally believe we need a separate disclosure, and that disclosure has been made.
Yeah, I also, am gonna echo a lot of the things that you said. Just for a little background, the commission reviewed a proposal to add a new title disclosure back in 2023. At that time, it was added to the commission's global forms, list. Last year, we declined to approve the title disclosure. And, while we did have a discussion, it was recently brought up in, public comment, which is why we decided to add it to the agenda. I do agree that disclosure is extremely important, and so we do very much appreciate, Mr. Wolf's dedication to this issue. I was amongst the commissioners that voted not to add the disclosure. I'm going to take it just a little further, because I just want to be really clear on why we decided not to, add it. First, this disclosure essentially made 9 disclosures within that disclosure. There were 9 disclosures within the disclosure. In part, the first one was that buyers have the right to shop and select the title company. Well, that is also echoed in the exclusive right to buy, section 16, and exclusive right to sell. And that was effective January 1st. So you actually read the clauses, so I don't need to revisit that. And the second disclosure in part said, a broker can't require a seller or buyer to use a certain title company, and a seller and buyer can shop and select similar service for other title companies. That again echoed exactly what is in exclusive right to buy and exclusive right to sell. The third disclosure that was made is that sellers and buy in part that the sellers and buyers are not required to use the referred title company and are free to shop around. Again, that's listed in exclusive right to buy and exclusive right to sell already. And then section 4 of his disclosure said, in summary, real estate brokers generally include the name and the selected title company in the MLS, which is premature and creates unwarranted position for the seller in negotiating the contract. While that is true, that brokers do put the title company in the MLS, in the exclusive right to, in the contract to buy and sell, brokers also have an option on who's going to pay for that title. So number 5, summary says that in summary section number 5 of his disclosure just gives wire fraud instructions, which is also stated in paragraph 9 of the closing instructions. Section 6 of his disclosure says in summary that the Division of Insurance regulates title companies and mentions fees can vary, which affect buyers and sellers. Well, again, that's echoed in exclusive right to buy and exclusive right to sell contract. Number 7 of his disclosure said in part that the Division of Real Estate and the Division of Insurance encourage sellers and buyers to shop and get multiple quotes. Again, it's reinstating shopping and the ability to do that. So that's already mentioned in exclusive right to buy and exclusive right to sell. Number 8 in summary says that sellers and buyers can have funds further protected by a closing protection letter. Now, I will say that this is an area that I could see a further disclosure. So maybe this is something that could be added, because I don't believe that we really disclose this. And a lot of people don't know what closing protection letters are, because typically if you have a lender involved in a transaction, it's part of the process. But if you have a cash buyer, they may not know that they can request a closing protection letter for a nominal fee. So that might be something that we look to add to our global forms list in the future. And then number 9, on his disclosure, it said the Division of Real Estate and Insurance advise sellers and buyers of phishing scams, which again is echoed in the closing instructions section 9. So while disclosure is important, the list was just a little bit redundant based on what we already have in the contracts, which is why we decided to not add it as a required document. So just wanted to give a deeper explanation as to how we process that decision, because we may not have all spoken to that detail, but we all did review it. And then when we came together, we just kind of summarized how we felt, but that's giving a little bit more detail, at least from my standpoint, why I didn't think it was necessary to have that disclosure.
Yeah, I think with all that information, I don't think we needed to add it either. So I guess, I don't know, but either of you have anything to add to that? Or if we want a motion to not add it?
I would agree. I mean, I think it doesn't, it's like over disclosure at this point. I have another one. I think that's why us brokers are being hired to provide that expertise. So I don't think it's necessary.
I think we need a motion on that, do we?
Yeah, you don't want to take action.
I mean, the only thing I would maybe take action on, as I mentioned, is the closing protection letter. Just adding that to the global list. So that we can revisit it when we revisit, which is probably in what, 2 years or so, when we revisit the closing instructions. Or maybe even the contract to buy and sell, something to look at later.
I agree.
So do we need a motion for that, or can we just put that as a?
If you could do a motion for that, that would be
Okay.
awesome.
Okay, so, I move to request that the closing protection letter be added to the global forms list for the, contract to buy and sell and or the closing instructions.
So you've got a motion. Is there a second?
Second.
Motion and a second. Any discussion? All those in favor say aye.
Aye.
Hi.
Any opposed say nay. Okay, that passes. So the second item under or the third item under policy matters was an issue raised by Cabby at the last meeting about continuing education approvals, and I think it also included an element of the potential of a course on shared CRMs. So we have AJ Jackson on the line today. She does the real estate broker continuing education approvals. And I had checked with her and also David to see if we'd gotten any course submissions from Cabby. And we haven't gotten any recently, but I will turn it over to AJ just to kind of let her fill you guys in on what she is seeing.
Thank you, Marcia. Good morning, commissioners and my coworkers and the attendees. Marcia's correct. We did take a look and we don't see any recent submissions. I know that there's been several people from the business brokerage industry that have reached out to ask questions about continuing education. The last applications that we saw were back in 2016, and those courses expired in 2019. And to the records that I found, we haven't seen any recent submissions. So I don't really have anything to address on if their material would qualify or not for continuing education. I don't see that there were any declinations on any of those applications because we haven't had any.
So I think it really just matters on what the course submission looks like. I don't want to say right out of the gate that a class on shared CRMs wouldn't qualify for CE, although like on its face value, it's client relationship management system. So it's going to depend on what the content of the course is.
I went back and tried to listen to that section. And there were two things that came up, and I think that she may have been asking for clarity on shared CRMs, on how that, the effect of that. And my take is if there's additional information forthcoming on the legislation for supervision, I think that's more of what she was looking for. So I don't think that we can really review that at this point because we have to wait until that comes down for us to dive into. So there really wasn't anything that we could do on that. Mm-hmm. Secondly, she was trying to get relevant content approved. Since nothing has been submitted, there's nothing to approve, but I see her request. If we have not had anything approved since 2016 for commercial transactions and for business brokerage transactions, that's a call. Like we see problems coming for commercial transactions regularly. We see problems with these transactions. So it would be great if we could see some courses being presented to the division that they could teach And I think that that's what we're lacking right now, is we need those available for those people that want to do those transactions and want to do them well. So I would just put a call out to instructors to put these together, get them in front of the division for review and approval. And get out there and start teaching more of these classes with good content for commercial licensees and for business brokers. So looks like
And
there's
if-
not a lot.
Yeah, if I might interrupt, I'm sorry about that. I did want to point out too that a commercial brokerage is not necessarily the same as business brokerage. So if it does have to deal with real estate, then of course, if it follows all the rules or that are aligned, that the commission is approved, then it's an acceptable course. But sometimes business brokerage courses may not be eligible for CE because that's a different entity. That's a different animal. It's kind of like selling personal property. It may have some real estate relations, but it may not all be eligible.
Right, but a lot of them are going hand in hand, and so that's why they're asking for some of the
100%.
clarifications, and so she specifically mentioned those, which would be wonderful to at least put out there. If they can teach some of those classes that people can be exposed to, that would be wonderful to have, and we just don't have those, so I appreciate it. Thank you so much.
You bet.
So lastly, commissioners, before I ask you for agenda items for the August meeting, I'm going to forewarn you that the August meeting is going to be a heavy workload for you guys, because we will have rulemaking to deal with the changes brought about by legislative changes. And there's a couple pieces. There's our sunset review, and then there was a Department of Law bill. So we're waiting to see when the governor signs them. But we are working, in addition to making the changes that are going to result from legislation that was passed in 2026, we're taking this opportunity to do kind of a little bit of a cleanup of some of your rules as well. And I will flag for you one thing that we've been dealing with. When you adopt a rule, your goal in adopting a rule is to address a gap in statute or to provide clarity of a law. It's not to restate a statute in a regulation. That really serves no purpose, because the statute regardless is going to be there and it prevails. So you will see, as we kind of work through the rulemaking, any rules that you have that say, like the definition of the division director, see the statute, we're going to be recommending that you guys repeal those because the definitions are in the statutes. It also sets up an opportunity where you may have a regulation that is not reciting the statute identically and creates a little bit of a disjunct, and the statute's going to be prevailing regardless. So we're working through the rules right now to kind of clean those up. And we will be addressing whatever changes we need to with legislation. So you'll have rulemaking in August. You're also going to have a non-rulemaking hearing. We are planning on doing the forms in August as well. I see the expressions. August is going to be a fun meeting, but so you'll have the forms also. Although I don't think that there's like really significant changes coming from the forms. So just keep that in mind along with whatever complaint matters. So with that, would you like anything added to your August agenda?
Oh,
Okay.
enough.
So the next matter on your agenda is hearing matters. Melissa is out, otherwise she would kind of walk you through this. But this is a review of the initial decision, and it's a request for reconsideration of sanctions in the Josh McNerlin case, and that's case number RC 2026-0004. Melissa prepared a memo for you, and to give you kind of a non-attorney description of the exceptions process. So when a case goes through the full hearing process and an administrative law judge renders an initial decision, there is an opportunity for either the real estate commission or the respondent to file exceptions. And that is appealing basically the initial decision. And they typically look at findings of fact or conclusions of law. However, in this particular instance, he's not disputing findings of fact or conclusions of law. He wants you to do a different sanction than what the initial decision came down with. And exceptions is also not an opportunity for somebody to raise new issues that were not brought up during the hearing. So just kind of in a nutshell, to remind you guys of the exceptions process. we thought that this was pretty straightforward as far as what this person is requesting, so we didn't engage conflicts counsel for this. But if you all decide that you want to have legal counsel, and this is where it gets a little different, because Irina was the prosecutor, so she can't provide you with legal advice. So if you want legal advice, we'll have to defer this to August and get conflicts counsel. But if you feel confident in making a decision today, you can go ahead and do that, and then we will do whatever you direct us to do as far as the disciplinary recommendation.
Based on the details of this file, I personally am comfortable making a decision without conflicts counsel. How does the rest of you feel?
Agreed.
I agree.
Agreed.
Agree.
Okay. Very much. All right, well. Yes, do we dive on in?
Bye.
Okay. So. A little bit of background that I jotted on this. In April 2025, the respondent and the commission entered into a stipulation for diversion. The respondent admitted to failing to comply with CE requirements. The respondent agreed to a $500 fine plus a 15% statutory percentage. And the respondent agreed to pay that within 30 days. However, so it's pretty minimal discipline. Respondent didn't pay when agreed, and in fact paid eventually about 2 months later. The respondent agreed to 24 hours of real estate education, but didn't appear to comply with that. And based on the notes here, that has not changed. So that education still hasn't been corrected. And so from there, the commission imposed discipline, which resulted in more noncompliance. So there was discipline ordered, that individual didn't comply, and it went all the way to the ALJ. And looking at what our role is, which is not to, really, we're looking at, did the ALJ misinterpret, I don't know if I'm saying this right, but misinterpret, the real estate law in regard to that. And there was no evidence presented from this individual that the ALJ's decision was wrong and that it was not lawful. So therefore, and then there was more noncompliance that the individual failed to answer the notice of charges. They failed to file a motion. So there's a history of noncompliance here. And therefore, I agree with the proposed recommendation set forth by the ALJ. And I would ask that we just continue with that.
I agree. I had no questions. He signed the stipulation. He was non-compliant with the stipulation. Then the respondent was non-responsive to the procedure. I don't think anything, I didn't see anything necessitating the overturning or modification of the initial decision. Because of this, I would move forward with the adoption of the initial decision.
I would second.
Do you have any comments?
I was open to letting him switch it just because he would be under supervision for 2 years, stricter supervision. So I was open to letting him switch that. As Melissa Phipps put in her note to us. So I thought he does have the history of noncompliance. And there was numerous letters that went out. There were numerous things that he didn't comply with. He just kept saying that he didn't understand the expectations. But because it would be moving his license to where he needs to be supervised a little bit more, I was open to switching it.
So commissioners, and just to kind of review what the initial decision was, is that the initial decision of the administrative law judge was that the respondent violated 1210-217-1M CRS, and the respondent's real estate broker should be disciplined by public censure, a civil penalty of $2,500, which includes a 15% statutory surcharge as required by state statute, and then a suspension term of 30 days to be imposed and to continue beyond 30 days until compliant. So I'm not seeing the 2 years of additional supervision.
Yeah, we're switching it.
It would be basically, he would be suspended until he paid the $2,500 civil penalty.
I have no idea where I got that, so I put down, so maybe my notes.
Similar to another case, yeah. Well, and great segue. Thank you for reading those charges. So,
Yeah,
I would like to motion that we adopt the proposed FAO as presented and delegate the authority to the division to make any necessary non-substantive revisions and to execute and serve the FAO.
I would second that.
Okay, so you have a motion and a second. Is there any discussion?
Sorry, I'm supposed to be doing this, huh?
That's okay. I will turn that over to you when we get to
Just stop doing
complaints.
emotions too. I gotta.
We'll ease you into this transition.
Thank you.
So you've got a motion and a second, no discussion. All in favor, say aye.
Aye.
Any opposed, say nay. And that motion passes. So we will get that FAO issued. And I will turn it over now to Sarah for complaints and audits.
Good morning, everyone.
Good morning.
Matter A is complaint number 2025-2407. On March 2nd, 2026, the respondent pled guilty to assault to strangulation, a class 4 felony. The respondent was ordered to complete a 2-year deferred sentence, 2 years supervised probation, 90 hours of community service, and $1,616.50 in court costs and fees. Possible violations include 1210-217-1N, 1210-217-1M, 1210-217-1P, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with a criminal sentence. And Investigator Martinez can answer any of your questions.
Okay, I'm gonna try to do my role a little bit better. Does anyone, let's just do it as we would with Robert's rule. So let's make a motion first and then have a discussion.
Right.
So, do we have a motion in regard to matter A?
I would motion to accept staff recommendation.
Second.
Any discussion? I agreed with the disciplinary recommendation, so. Any other discussions?
I have it on mine, the same, agree with disciplinary recommendations.
Yeah, I would agree, sure. Yeah.
All in favor?
Aye.
Any opposed? All right, motion passes.
Matter B is complaint number 2025-1041. The complainants purchased the subject property with the respondent serving as their buyer's agent. Prior to the sale of the property, both parties discussed and agreed that the respondent would assist the complainants with post-sale repairs. The complainants alleged that the respondent misrepresented the cost of repairs and profited from assisting with repairs without disclosing any markups. The investigation found additional possible violations related to written disclosure of a potential conflict of interest and accounting of money belonging to others. Possible violations include 1210-217-1W, 1210-217-1Q, 1210-217-1B, 1210-405, 1210-217-1H, 1210-217-1M, and Rule 5.21. Discipline recommendations are public censure, a final agency order, a fine of $10,000, coursework in ethics, coursework in trust accounts, and coursework in legal issues. And Investigator Peters is here to answer any questions that you might have.
Thank you. Does anyone have a motion on matter B?
Motion to accept staff recommendations.
Do you have a second? Discussion?
I can second it to get it into discussion. All right. This one had a lot going on.
You did.
So
And that was the second official.
that was an official second.
Okay.
Sorry.
For the record.
Does anybody else want to start the discussion?
I can say initially, reading through, there is a lot of layers here. And my question was this individual the connector? Or was this person acting as the contractor? Or the general contractor? Because it's one thing to connect your clients to a contractor, and it's another to be a general contractor in that transaction. But then I answered my own question as I really reviewed the case again, because he did collect money directly. So he was the middleman collecting the money. Additionally, he was going to the site to check progress. So whether they had a written agreement that he was a general contractor, he was acting in that role of a general contractor, which I think at that point kind of muddies the water a little bit. And so because of that element and because of the answer to that question for myself personally, I supported the staff recommendation, but definitely open to hear other perspectives. So I know you.
Yeah, I mean, I had the same questions as I was going through and then back through again. Because I do think one of the things that we do is connect people on a regular basis. But the second he stepped in, I think 100% he was doing general contracting duties. And he was bidding the work for them. He was hiring the subcontractors, he was supervising the subcontractors, and he was paying the subcontractors. But then further, he utilized his own companies that he owned 100% out of and at least invoiced through his own companies. And it appears taking a cut of the profit. So a lot of that would be acceptable under the license of a general contractor, but not if you're not a licensed general contractor.
Well,
Yeah. I wasn't sure if he was licensed to be
He's not.
to that. And then also encouraging his client to walk around permits and do a lot of the work unpermitted. It's one thing to paint a house without a permit, but if you're doing heavy like updates to the home, it should absolutely be permitted. So it's a warning to people, I suppose, if you have a contractor who's trying to tell you they can do massive upgrades without permits, like take a moment and really think about what you're doing.
Well, and he has no insurance for the subcontractors, for any injuries that might happen on that property, for the problems that would be incurred that the people that were working on there would have. I mean, the insurance aspect of that I think was huge.
Yeah. And also the work wasn't warranted because it was kind of like backhanded deals. So yeah, just the whole thing was pretty disorganized from the begining.
I think he also knew, like from his initial Facebook post mentioning that they would, he was gonna help them build 300,000 in equity in this property. He was hands-on and he mentioned in his post itself that he was gonna be helping with the renovation. So it wasn't just connecting. If he was gonna be connecting, it would say something like, I'm connecting my referral partners that, you know, something along that line. And there was none of that either. So he was full hands-on with this whole thing. So that's why I agreed with the disciplinary recommendations.
Yeah, that Facebook post, that was the other thing I forgot to mention. It had it in my notes, but I didn't read that. But big meat of the complaint was that they were promised equity, which I mean, I was a little apprehensive about that because we know as industry professionals that you can't really promise anything in this industry because you close your eyes and it changes. So that I was a little apprehensive. However, then he did put on Facebook and specifically said that they're gonna gain 300,000 in equity. So with all of that, I mean, it's a hefty fine. It's hefty discipline, disciplinary consequence, but this individual lost a lot of money. I think over 300,000, I want to say. Where's the investigator?
I think they said that it was, ended up costing them 150,000 to do the renovation instead of the 75 that he told them that they would, if they invested 75,000 or do some work up to like 75,000, some minor upgrades, because the house was livable when he moved into it. But if he added $75,000 worth of upgrades or, something to it, they would get 300,000, which I can't wrap my head around that. Those numbers, anything like that. And then to take it all the way down to studs, I don't know how you even think to take a house down to studs for 75,000. I wish it could be done, but I don't think so.
Yeah, I think there was just a lot of misrepresentation across the board on this one. Just
Yeah.
because he estimated the value of the after renovation to be way higher than it turns out to be. I think it's just, they were first time buyers and I think he was taken for a ride. That's what it sounds like.
Well, the buyer was 2 feet in on this. I mean, the buyer he knew that the buyer went into this knowing that he was gonna start real estate investing. And so maybe he found somebody that was very eager. Granted, he didn't search this buyer out, the buyer was referred to him. But I still think it's still a first time buyer. A first time buyer doesn't know.
Yeah.
Doesn't know everything about it. I don't care if you're sitting in a real estate investing group a year. There's still a whole bunch of stuff that you're not gonna get out of it. So, I think he knew.
As a licensee, when you're in that predicament of you have these companies that are construction related and you're referring a client to your company, that creates that conflict of interest that like you need disclosures and things of that nature. I mean, had that client been referred to a third party was handling third party mess things up, that would have been a different situation. But because he's directly involved with the companies, that created
There was the name changes on some of those invoices too. There was some discrepancy on that, the names on the invoicing.
Yeah.
So I think there's just way too much.
So we have a motion and we have a second. It sounds like we're all in agreement. So all in favor?
Aye.
Aye. Any opposed? Motion passes.
Investigative matter C is complaint number 2025-563. The complainant alleged that the respondent failed to perform her due diligence of confirming the identity of the seller to ensure the sale of her vacant land was not a scam. Possible violations include 1210-217-1Q, 1210-217-1M, and Rule 6.2. Disciplinary recommendations are diversion, a $500 fine, coursework in ethics, and coursework in legal issues. And Investigator Gabardi can answer any questions that you may have.
Do we have a motion?
A motion to accept staff recommendation.
A second?
Second.
Discussion. I definitely have a lot of discussion.
Yes.
So do you want to start or do you want me to
You start,
start?
you go ahead.
Okay, so my first question here, I'm gonna be honest, I don't understand why we're considering discipline on someone who was also a victim of a scam. That's my perspective of this. The agent in question was contacted by an individual. That agent went into Forewarn, which is a realtor app that allows you to put in someone's phone number and it pulls up their contact information. There was no red flags there, according to the agent. All the other things checked out in terms of that imposter knowing information about the property. So ultimately, the owner of the property sees it listed and says, hey, wait, I'm not selling my property. You've been scammed. That agent responded immediately, pulled the property. Property did not sell. There was no harm. That agent reviewed the file. This is before they listed it. So she did the forewarn. There's no red flags. That individual reviewed the file with their managing broker. They listed the property. Once notified, she removed it. And I don't understand what else really that individual could have done. I mean, we are trained to do our best due diligence, but we're also not like actual investigators. So we do our best. We try to minimize risk, but I don't know what else this person could have done. Number one, the forewarn too, it mentioned that, and I use the app, so I'm talking from a place of actually understanding how the app works actually as a user, not just hearing about it. And forewarn leads with the phone number. In the investigation, it said that forewarn said they lead with name. Problem with that, yes, you can put name. It's secondary, by the way, when you access the app. You can put name, but if you have the name, you need to know about where they live. Like, do they live in Colorado? Do they live in Arizona? You have to know about how old they are. So you can't really use a name to determine if this person is an imposter. So you're using the phone number, is bringing up information, and then you're checking balances from there. I think this agent did everything that they could to eliminate risk. Unfortunately, it's really easy to say what you could do when you're scammed, or you're in the middle of a scam. You don't know that. So I am of the opinion that this case should completely be dismissed. That's my 2 cents.
Oh, I'm sorry. I was just really confused because as I read on in the file, it sounded like this, for whatever reason, this particular property had been targeted by this fraudulent actor. And it sounds like there were several other agents that were contacted with the same scam, but caught it. So I guess that's my question.
I think at minimum, because she was contacted by phone. But I'm coming from a different place though, because everything I do, I'm asking for ID. Like I want to know who I'm dealing with as far as in any banking, right? I want to know who you are. I'm asking for an ID. So I could see asking for an ID if you're talking to somebody. But I do also see that this property was targeted, probably 2 or 3 other times. Whoever the person was knew that the homeowners lived in Massachusetts, if I recall correctly. That the homeowners lived in the landowners lived in Massachusetts. So, but do I think that she did it? I mean, I could see asking for an ID, that's it. I don't think that she could be, I think she did do her due diligence on it. I don't think asking for her license is really logical in this. The other part is I also know that if you've been scammed, if you've been a victim of fraud, right? Credit card fraud, any type of fraud like that. The landowner was asking, I want the information for this person that contacted you. I want this information. I want this information. I want this information. In banking, you still can't get that information, even as a consumer. If your credit card is used and it's paying somebody's cell phone bill, you're not going to get the cell phone that it was paid for, that your credit card was paid on. You're not going to get that. So even I can understand the homeowner being mad. She didn't get enough. She wanted more information, but it's not going to happen no matter what. She wouldn't get that. And so I think the agent still did her due diligence. but I would say maybe ask for a driver's license. That's why I did agree. Just with maybe some sort of, I don't know exactly what education would do that. That's offered for that, but that would have been my recommendation on that.
I will say that I don't disagree. It's not necessarily brokerage's practice to require ID. It's a good practice. But it's not something that is just an automatic practice of a brokerage to say on every transaction, you need to do this, this, and this. There could be brokerages that do that, but industry-wide, it's just not. Common practice is definitely good, especially when you don't know someone to get that information. I wouldn't ding this person for something that isn't a requirement, right? For not having ID. The other thing I just want to point out, because I'm reviewing the case again, but I don't see where this happened to that property more than once. I think what I recall, and I'm looking and verifying, is the brokerage had maybe like a class about and discussions about scams that included people scamming for land, but not that this one.
There was a report
For this actual property?
Yeah.
From the homeowner. The homeowner stated that.
Yeah.
So is there
They caught it.
written, yeah, that she says that she caught it? That she spoke to another agent and the other agent said, I can't believe this happened. This should be a violation, da, 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 da. But it was caught. So she's going off of what another broker told her. This should have been caught, violations. And so that's where she got her, I think that kind of amped up her, something needs to be done.
Yeah. And there's different levels of experience too. Like
That is
a more
true.
experienced agent would know, oh, this is a red flag, but if you're a few years in, you may not have that same.
And she stated from the very beginning, even through her text messages, I've never done land.
I can jump in on that though, a little bit. I think this agent as well, I agree a lot with what Erica says, and Bernadette, I see where you're coming from as well. But she looked up the phone number on Forewarn, which matched. She called the title company for additional information on it, which I find very few agents do and should. She had her employing broker, she called her in from the get-go saying, I need assistance and I would like for you to oversee all of this. So she had her employing broker over the top of it. She visited the property. She could have asked for an ID, okay, but I agree, that's not industry standard. If it needs to be industry standard, we need to tell everybody that this needs to be industry standard so that we are doing that. But I feel like this guy was a scammer. I'm like, if we feel like this guy was gonna give the correct ID from the get-go, then we are crazy. I think he would have provided a false ID. So they were able to shut it down before it got under contract. And my question too is what else could she have done? And I don't want to penalize the victim for being a victim when she did, in my mind, everything that she could have done. Except for that potential ask for an ID, but I do not believe that would have been a valid ID.
So the one thing that doesn't add up though, it looks like the owners called the brokerage that she works for, and the brokerage told her that this is common, this scam.
It is a common scam.
So they should have then pushed her to identify a little bit more, you would think, right?
Her managing broker.
Yeah, the managing broker should have pushed her to verify the identity of who this buyer or the buyer.
The seller.
Or the seller, yeah, I'm sorry, the seller. And it sounded like she was a little unresponsive. I don't know if she was delaying or what, but I'm not
She
sure.
said she was
why.
busy. Yeah,
You're talking about
The
agent
broker,
or
yeah,
the agent.
so, it's hard to say. I mean, it does sound like a pretty tough scam to uncover.
And we've seen.
She did her work.
Yeah, we've seen other ones where it was just like blatant, they did nothing, no research,
Yeah.
just threw it up on the market, like 100%, you've got to be on your toes. But this one was much more on their toes and brought in help and did a lot of the things that we are recommending, did them, check. So it's just kind of, I don't know, I hesitate at I mean, if we're gonna come back at this, we need to be telling very clearly what else this person could have done.
What's the recommended discipline?
Diversion, $500 fine, coursework in ethics, and coursework in legal issues. I don't think it's ethics.
Yeah, I agree with that.
It's definitely not ethics.
And I really think,
And I didn't even know if I really that. I don't know, if legal issues covers that. That's why I was unsure when I
I
said,
don't know that a violation actually occurred.
Yeah, I would also throw this one out.
So do you want to make a motion to dismiss?
I will motion to dismiss.
So we have the previous motion, so.
We already have a
amend the
motion, yeah.
Yeah.
Sorry, also. All right, I would amend the motion to dismiss.
Second.
I could go either on that with what you said. I mean, my mind always wraps around ask for an ID because everything I do is verify who you are. But if it's not required, then I could see dismissing that.
If I can just.
Oh,
point
go ahead.
something out. Aside from not asking for an ID, she never spoke with the imposter. So there was never a conversation over the phone. She relied on the text or the emails just to be who she thought she was speaking with. I don't know if that
Thank you,
changes
Nicole.
anything, but just
That's
an
an
added.
excellent point.
Her conversation was the text. Why was I thinking she said that she spoke to
I
him?
thought so too.
That's what
That
I
was on the
thought.
back end after the fraud had occurred. She actually talked to the actual landowner at that point.
No, Commissioner, she did speak once with the imposter, just once. But
Oh, yeah.
otherwise, all the communication with the imposter, including wherein he told her that he was in a facility in Texas battling colon cancer and couldn't get the documents that she was requiring. Everything was via text message other than the very one short, I think it was less than 5-minute conversation she had with him. Otherwise, everything was via text message.
And I appreciate that clarification. Thank you. I do remember seeing that she had spoken to the imposter. When you have an out-of-state client, at least for me, I've had personal experiences where that's not really out of the ordinary, where maybe that initial conversation is human voice to voice, but there's a lot of, emailing and texting that happens. And more of the meat of those in-person conversations, in my experience, have happened more like when you're in that contract phase, and then, maybe you ramp up that in person. But I don't think that's completely abnormal that she spoke to him for a little over than an hour, and then everything else was text and email. So it doesn't really change my position.
I agree. I would say the bulk of all of our correspondence is electronic nowadays, very little on the phone. So that is not a huge red flag.
So we have a motion and a second. All in favor? I'll call.
Aye.
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 Hi.
So the motion to dismiss passed.
The next investigative matter is D. It's complaint number 2026-486. The respondent pled guilty to a misdemeanor 1, assault 3, no reckless cause injury. She was sentenced on February 25th of 2026 to a 12-month deferred sentence and $78 in court costs and fees. They have been paid in full. Possible violations include 1210-217-1N. And disciplinary recommendations are diversion, a fine of $250, and probation to run concurrent with the criminal probation. And Investigator Gabardi can answer any questions.
Okay. Do we have a motion?
A motion to accept.
Second?
I'll second.
Any discussion? I agree with the staff recommendation. No issues there for me.
Yeah, no, my notes, agree with staff recommendation. Yeah.
Yeah, Yeah, no.
Autumn,
Agreed.
Erica? Great. Okay, all in favor?
Aye.
Aye.
Opposed? Motion passes.
Investigative matter E is complaint number 2025-2351. The complainant alleged that the respondent did not disclose his license status.
Hold on. So sorry to interrupt. I was turning the page. Due to, actual or implied conflict of interest, I will recuse from this discussion. Where should I go?
So if you want to go up there,
Okay, just,
And then I will-
plug it to the front?
Yeah.
Okay, and then
I'll
somebody
touch
just
it.
come grab me. Sorry, I couldn't flip the page fast enough to see it.
you are up, Erica.
Oh, no. Okay, here we go. All right, go right ahead.
Okay. Investigative matter E is complaint number 2025-2351. The complainant alleged that the respondent did not disclose his license status in the contracting instrument and did not disclose adverse material facts related to the remodel of the property. After the closing, the complainant spent approximately $300,000 in repairs and mitigation due to substandard remodeling issues and non-permitted work. Possible violations include 1210-217-1C, 1210-217-1M, 1210-217-1Q, 1210-217-1W, and Rule 6.2. Disciplinary recommendations are a final agency order, public censure, revocation, a fine of $10,000, and Investigator Geske can help answer any questions you may have.
Okay, do we have a motion?
I'll motion to accept staff recommendation.
I'll second that.
Let's go into discussion.
Again, we have non-permitted work, people acting probably not very ethically in regards to this. I completely agree with staff recommendations here.
There were a lot of layers to this one too. A lot of different things that happened with this. And I think one of the biggest is there was actual harm done to the homeowner who purchased that property and ended up still out of pocket for $300,000. On top of already purchasing that house and then having to redo it all. Let me see. So I have, agree with staff recommendations. He should have also stated that he was, granted, he might have mentioned it, but there was no disclosure document stating that he was the licensed agent on that. I think there was just too much with this, a lot of different layers with it. So I put to agree with staff recommendations.
I wonder if we can break this up into a couple of sections. The first one, where they were really keen on, well, let me go back up here. The disclosure, because I would like some clarification on this. And partly because, and I may bounce around a little bit, but he was not his own listing agent on this.
No.
Right? So the disclosure, and I pulled up the rule just to make sure. It says, the duty to disclose, if a broker sells, buys, or leases real property on the broker's own account, such broker must disclose in the contracting instrument or in a separate concurrent writing that they are a licensed broker. He was not the broker on this transaction. He hired an agent. The agent put his disclosure in the MLS, so it was there, but it wasn't in the contracting documents. So my question for your thoughts on that, was that sufficient? Because when we listened to the recording on this one, that was really hard too, because they all four said something different.
Was that Commissioner Doyle? If I may.
Yeah.
As read, the charges, we are not, the division was not suggesting to charge 6.17.
Oh, okay, all right, so, but it's still important that he hired his own agent on there. On this particular one, well, it says. The respondent did not disclose his license status in the contracting instrument
In the report? Are you reading from the report?
on the referral.
It might say that on their referral, but we're not actually charging that.
Okay,
Down below.
so. All right. Well, I'm still going into my question on this because he did not list the property. Let's go into that one. Okay, we can move that one. So then the issues with the house. A question for the investigator. I did not find any previous inspection reports or seller's property disclosures. Were there any provided on that?
No, there were not. And it was requested the previous, when he purchased the property, I believe in 2022. The respondent just stated that he didn't have the previous seller's property disclosure available.
So not having the inspection reports, and when he purchased the property, they talked to the agent that represented, and that agent also didn't have any documentation, correct?
That
represented him when he purchased it?
That agent was non-compliant as well.
Okay. Where I'm heading with this is there were no disclosures that he is saying he had nothing to disclose on that. I think it's important because I also don't have. We had the buyer's inspection report on this. Was the only inspection report we had to look at, correct? As far as this issue. As far as anything wrong with the property was the buyer's inspection.
Yes, ma'am.
Okay. I am heading somewhere on this. I'm just trying to stay organized. Discussing the seller hired an agent to sell the property, so he was not the listing agent. The seller agent, when talking with that person, she was not aware of any previous inspections that he did on the house. So there were absolutely no disclosures for us to look at all from previous purchase or from a disclosure perspective other than what was done to the property. So the respondent states he was an investor with the purchaser. He hired a professional contractor to do the work on the property, correct? He didn't do any of the work himself.
Correct. He hired a handyman.
Okay.
And the respondent did own the property.
Right, the respondent owned the property.
LLC.
Through an LLC. But they did an interview with they tried to track down the contractor.
Correct.
They talked to the contractor's father. The contractor's father said that they were licensed.
The son.
Yes.
It's reversed.
So then the buyer did an inspection, and then when they did this, they did an inspection objection that lists issues both with electrical and with plumbing. And then received $30,000 of a financial accommodation for the inspection items requested, and the buyer signed off on that inspection resolution. So they received accommodation for that. So it does seem to me that the buyers are challenging like over the quality of work And if Phil, the respondent, didn't disclose that he knew something he didn't do. But I didn't see anything in my files documenting knowledge of non-disclosure, and that's what I'm looking for now. I'm asking if anybody else saw anything like seller's property disclosures, previous inspection reports, anything like that. I looked, but I'm not seeing that. Other than,
They were requested and not provided.
okay, because I really feel for the buyers that had a lot of problems with this property after they bought it. That's a problem. But if I don't have anything in writing from the sellers or on the seller side that is documentation of anything, I don't have it. That's what I'm looking for here. And what they did do was come back and they let them do a full inspection. They provided an inspection report. They addressed the inspection report with $30,000 of accommodation. And that's supposed to be it. Like I'm asking to find out, can you tell me any piece of documentation in here that I should be looking for that I might have missed on what he knew? Because I couldn't find it.
The requested documentation was never provided to the investigator myself.
But none of it, but. Okay, so still, if they were doing the work unpermitted, when you're rehabbing, especially to this level, there has to be electrical inspections that's done through the state. There has to be plumbing inspections that also get done through the state. He's the owner of the property. He should know if there were.
He hired somebody to do that, and that's the contractor.
But there still has to be permits. He's aware whether they pulled permits or whether they did not pull permits. When you hire a contractor also tells you, hey, we need permits, we need this, or you could do a homeowner's permit and still hire somebody to come and do this, and work with them. But it was unpermitted work. If it was permitted work, they would have seen the damage to the 3 shower pans, that it wasn't complete, that they did a bad job on that, the electrical that could have easily caused a fire. It was still unpermitted. So whether he's the homeowner, he knows he's still a licensed agent, no matter what. He still knows what needs to be done. So whether he had any of the paperwork, he still didn't pull permits. He knew that there needed to be permits.
I'm just saying what I heard in the interviews, the contractor told the respondent he didn't need permits. Respondent believed that he hired a qualified contractor. So I'm just trying to look for the information that was requested. Mm-hmm. And I'm just trying to gather that information, because I can go through the paperwork very easily and say, you did this, 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 and I'm missing a lot of information that would have been helpful. I understand they didn't respond. Mm-hmm. But I'm looking at the paperwork that was here and the accommodations that were made. The other thing that was interesting, and this is rough, but there were multiple places in the inspection report where the inspector further recommended that the buyer obtain a qualified contractor to evaluate, in regards at minimum, the electrical and plumbing. And they didn't do it unless, go ahead.
The respondent said he didn't know. He didn't hire a licensed contractor. He didn't know if he was licensed or not, who he hired to do the work. And he didn't know if any permits were pulled or not pulled, should have been pulled. And when he purchased the property, he told us that he didn't know of any issues, because he just came in and fixed everything and replaced everything. So it's a lot of, I don't recall when there were a lot of red flags that say you would know if you needed permits, you would know if your contractor was licensed or not. And the respondent's basically just not cooperating and saying, I don't know.
And that's fair. I'm just going off of the interview it was a very short interview that he tried to get with the plumber's dad. So I don't know how you weigh that. He asked the question, are you licensed? And I'm paraphrasing on some of this. And I thought he said yes on that aspect, but he asked on that one. But I'm going off of the paperwork that I have here. I understand where you're coming from on that. I don't know, I'm just going off of the paperwork I do have. I don't have inspection reports from a previous purchase. I don't have seller's property disclosures from a previous purchase. The listing agent who he hired doesn't have that, anything to disclose previously.
I think that there was, in the contract originally, they had asked him to disclose all permits. And then the amended stack came back with that removed. Again, it's just kind of the circumstantial, if you put it all together and take a look at the whole picture of everything.
Okay.
You know, it's sometimes
Looks like
there's
he was
not.
trying to hide something.
Yeah, sometimes
Yeah.
there's
Yeah,
not
that's
a
what it-
hard document that's like.
Yep.
And I
Because
did,
it appears the respondent removed the reference to the request for the disclosure for any improvements made to the property without a permit. I think
So-
that says a lot. And then the inspection company, how you missed $300,000 worth of repairs.
Yeah.
It strikes me as a little.
yeah,
But, um,
The inspection, I know it did say in the inspection to ask for a licensed, to get the plumbing looked
So
at
you
and the
got some
electrical,
of
because some of it, if you look at the pictures, he provided pictures of what that electrical needed to be in a box. There's, I mean, that's a
and they
fire
followed
hazard.
through on that, the
And,
buyers.
yeah, and the buyers didn't, so
Yeah.
could the buyers have done better at the same time? Yes, but they're not gonna pull tile up to see everything that was leaking.
And there hadn't been any
I still think the
person
respondent knew.
living in the house
Yeah,
as well.
Excuse me?
There hadn't been any person living in that residence prior to the sale, so the items that may have been corrected were not tested either until the buyer purchased the property and started living there.
Okay. Commissioners, and if I may, if you feel like you need a specific advice on specific legal questions, we can go into executive sessions on this specific
Yeah.
case, and I have a script ready.
and I guess where I'm coming from is I believe he knew more. I will say I will believe he knew more. I don't think you can own it like that for that long and not know something. So I do believe that. But that being said, I wanted to, if we're looking at revocation, I think that we need to dive in very deep and look at the documents that we do have and what happened. What I do have, the respondent and his partners hired when he purchased the property didn't have any reports or disclosures that they're giving us or that they didn't have. He said it only needed updating. He didn't do the repairs himself. He hired what he said was a qualified contractor. He paid the contractors over $180,000 for upgrades, which is not an insignificant amount, showed us checks for that. Didn't list the property himself. He hired a realtor to sell it. She didn't have any reports or additional disclosures to provide. The claimant had a full inspection done and provided it to us. The inspection recommended he obtain qualified contractors to fully evaluate the electrical and the plumbing. I don't have additional reports. The respondent accepted $30,000 for concessions. And he signed an inspection resolution. So those are my thoughts. I would love to hear each of your thoughts on these as well. But those were my questions.
Yeah, I think that there was a little irresponsibility on the buyer side. I did not follow through with some of the stuff, but I think he was definitely, the respondent was definitely hiding known issues. I think that's pretty clear. So they did sign the resolution of.
That the signing the resolution free him from not, I guess that's what the question is, does signing the resolution free them from not finding out that that the work wasn't permitted, that he acted, in my opinion, unethically. But being unethical is not illegal. But you still have a whole house that there was a lot of stuff that went, and it still cost the buyers $300,000 in work.
And Erica, to one of your points, you make the distinction that maybe he didn't know whether the work needed to have a permit or not, and he entrusted a contractor. And that's true, but the property disclosures specifically asked, was any work done with a permit or was any work done without a permit?
You're correct.
And so he did know that part. And I know that as a buyer, if you see that there's checked box that says there was some work done without a permit, your level of due diligence all of a sudden gets greater.
Absolutely.
And so the buyer was denied that piece of information, which is pretty obvious, pretty clear, pretty straightforward.
I agree with that 100%. I do.
He admitted he did not have any permits pulled, and electrical was done, plumbing was done, and he didn't disclose no permits to the next buyer.
I mean, I could take this even a smidgen further on that. Because if you disturb more drywall than than what's considered a one sheet of drywall, you need to have that tested for asbestos. Could there have been an asbestos spill inside of that house? And then has that affect all of the HVAC, everything? So having no permits, they'll be lucky if it's only 300,000 and there wasn't anything like an environmental spill included in that. So, and that's required to test drywall. So I 100%, I think he did not do his due diligence on that at all with not pulling permits on this, whether he hired somebody or not. There was a lot that needed to be done. And I think that the homeowners ended up paying the price on this one for sure. Autumn, did you have anything to add to it?
No, I mean, I agree with staff recommendations based off of everything I've read.
So did you want to go into executive session and talk, or do you want?
No, I'm comfortable. I appreciate everybody taking a look at that, and we can go ahead and vote. All in favor?
Aye.
Aye. All opposed? Motion passes.
Okay, thanks.
Welcome back.
Oh, thank you. Okay.
Yes.
Okay. Investigative matter F is complaint number 2025-2250. The investigation noted potential license law violations associated with the respondent's property management agreements, lease agreements, disclosures, supervision, and trust accounts. Possible violations are 1210-217-1I, 1210-217-1M, 1210-217-1Q, 1210-404, 1210-408, Rule 5.5, Rule 5.14, Rule 6.2, Rule 6.3, Rule 6.5, and Rule 7.1. Disciplinary recommendations are a final agency order, a fine of $10,000, coursework in brokerage administration, coursework in brokerage relationships, coursework in property management, coursework in trust accounts, and a downgrade of a license to an FA for 2 years and an audit within 3 months. And Investigator Geske can help answer any questions that you might have.
Okay, do we have a motion? Motion to approve.
I'll second that.
Any discussion? There were a lot of violations. But, you know, kind of echoing the complaints, slow sending the deposits, having unlicensed people signing contracts, violations with trust account forms, ledgers, etc. So I also agree with the proposed discipline. Here's Tom, with this being your space. You had any notes or thoughts about this?
Well, they owe triple damages because they didn't get it in on time. Their own contract said there were 60 days, they were at 95 days. So, yeah, I mean, I would agree. I mean, there were violations across the board on this one.
Okay.
Say took over 90 days to get, to receive their security deposit, doesn't keep proper records, is more hands off, but his name is tied to all of it, so your name is tied to it, you are responsible. And so if your name is gonna be tied to it, then you need to make absolutely sure that the rules and regulations are being followed. That's why they're in place, to ensure that, there's no damages, no harm. I mean, 90 days to get your security deposit back is, I haven't rented for a long time, so, a very long time, so, but it shouldn't take that long, and there's rules with it, so, if you're licensed, then you need to be, you need to take that seriously and follow what the regulations are. So I agree with staff recommendations on that.
Any notes from you, Autumn?
I agree with staff recommendations.
I agree with staff recommendations.
Okay, so the motion on the table is to accept staff recommendations, and do we have all in favor?
I,
Opposed? Okay, no opposed, so motion passes.
Investigative matter G is complaint number 2025-1255. The complainant is a Section 8 housing authority who alleged that the respondent failed to disclose to the housing authority and the tenant that there was a separate lease for the garage storage unit. The investigation found that there was insufficient evidence to prove a violation around that allegation. However, the investigation found that there were potential violations concerning record keeping and documentation. Possible violations include 1210-217-1M, 1210-217-1Q, Rule 5.14, Rule 5.21, Rule 6.5, Rule 6.20, and Rule 6.24, Rule 6.25C, and Rule 7.1B. Disciplinary recommendations are a final agency order, a fine of $5,000, coursework in brokerage relationships, coursework in trust accounts, coursework in property management, and an audit within 3 months. And Investigator Peters can answer any of your questions.
Thank you. Do we have a motion?
Motion to approve.
A second?
I will second.
And let's have discussion.
There was a lot with this one, boy. Cause I could see renting out a garage, a detached garage. I could see that. But it doesn't state that. And I get that there are two different, leases. But the first lease, the main lease for the property itself doesn't state that it excluded the garage. And I mean, my feeling it can't really play on that, but I think she also knew. I think the homeowner knew, or the renter, I think she also knew that, she could get her voucher to cover just the house and then pay out of pocket for it. That was my gut on that.
Can I ask a quick question?
No.
I'm sorry to interrupt. I'm confused. Are we discussing whether or not the garage should be included, or is this a separate discussion based off of what the investigation found through the process and then kind of said that the garage storage unit is no longer up for discussion because they couldn't find sufficient evidence to prove a violation. So we're talking more about what they did find through the audit. Am I correct here?
Yeah, no, that's
Okay.
right, yeah.
Okay, I just wanted to make sure I was on the same page.
Yeah, I was gonna say, I mean, there were issues around the garage, but, they just couldn't support, they didn't have evidence to support any of that, so we're really just looking at the record keeping, violations, the, sorry, I'm trying to look at my notes here. There's record keeping, there was disclosure issues, file.
Documentation.
Yeah, I don't
any
think
sort of-
he
It seems like,
Never provided the file.
Yeah. Yeah, they weren't doing, and all their documents were non-compliant. PMA, the property management agreement, the lease, all non-compliant.
Mhm.
The lease, I think, was non-compliant for sure.
Yeah, property management too, because it needs to be, have an attorney paired. But they didn't provide their freeway recs, bank statements, just about everything that they was asked. It didn't seem like they provided.
Right.
So, I mean, sounds questionable practice across the board.
Yeah, I mean, I definitely agree with the recommendation.
I think they're actually light.
Did you have a different
No,
recommendation there?
You can change, you can
make a suggestion.
How many
That we can
properties do they
discuss.
manage? Do we know that?
how many investigator might
Do
know.
we know how many properties they manage?
Yeah, he said that he managed approximately 265 doors and about 60 different owners.
And the fine was.
And you still never got a
5,000?
file? Transaction file?
That's correct. I have not received anything other than what's in the report. There's no new information.
Well, they definitely need to be audited in 3 months, for sure.
Yeah.
What the fine was, what, 5,000?
5,000.
And we can go up to, what is it, 2,500 per?
2,500
Per statute violation, let's say.
violation, yeah. 2,500 per violation.
So it's already there,
Community violation.
yeah, and they did
So we've got,
5,000.
as far as
So you can reevaluate
violations,
again at the next audit.
It's not there, because
we've got
it's
possible violations,
statutes.
and those are the rules.
So
Yeah,
another.
so
So
this is the size they get up.
Violations.
So we can do the rules, okay, yeah.
Yeah, you can
Yeah.
do the rules, you just can't,
Is that one of
one
these?
M, we don't. So you would add up like
Yeah.
one Q and then the rules.
Gotcha.
We generally don't max out unless it's.
That's
Okay. Yeah.
So you have 8.
But let me
Maybe
show you
it's
on mine,
another-
because I don't want to mess yours up.
Well, here, we can go,
It's this one. It's the ESP referrals.
okay.
Yeah, I had to open a couple different
Okay.
windows to look at them.
Yeah.
Okay.
This one.
So if you did maximum fines, that's $20,000.
So just open this.
And I don't think
They're not there
maximum,
yet,
no.
Yeah,
I mean,
Because he is gonna be audited again within 3 months, so we
Yeah.
can see if he's compliant there and
yeah.
bring it up.
So, just so that he has that clear, the, fines can be for the violations and the rules?
Yes.
But not one end.
So currently you have 8 violations. So the maximum amount of fine, I understand that you would not want to go maximum, but 20,000 would be maximum. So from anywhere from 0 to 20,000, that's range.
So if you want,
yeah,
if you thought that I mean, this is more of your expertise.
yeah.
But if you thought
What's appropriate, but
and those are the rules, so we can go up to 20,000 if you thought it was low. And then you can still
yeah,
mention if there's more of an audit or anything like that. I mean, obviously we have they're suggesting the audit in 3 months. If there's something that you want to change
I'm
on
curious
that.
though, what coursework there is available for property management, because there really isn't. That's what,
They have.
Here is-
Yeah, they have,
is there, okay,
We have a catalog and.
okay.
Yeah.
Did you wanna raise a fund?
Yeah, I mean, well, he has to pay back that money too, right? Like $19,000 to the tenant.
For the,
For the garage.
For the garage.
Yeah.
I don't, is he paying
No.
that back?
Yeah.
No,
Oh,
No, it's not.
okay.
Oh, he's
that
not?
wasn't determined. That was a civil issue between the Section 8 housing and the
For
tenant.
us, it's not really a
Okay.
point of, it's not really a point of concern for us
I
in
might
this
bump
regard.
it to like 7,500. I mean, it seems pretty
7,500.
light, 5,000 for when, for all the violations here. There's a lot.
I don't disagree, mainly the fact that he didn't produce transaction documents.
Yeah.
I mean, that's concerning. So,
Yeah,
so we
they're-
would need a new motion.
Or you
Um,
can amend it.
Okay.
Yeah, to, for,
To raise,
to accept
okay,
with
so I
the,
make a motion,
Yes.
increase the fine to
yes.
7,500.
Yes.
All right.
To accept staff recommendations with amending the fine to 7,500?
Yeah, that's what I'm saying.
Okay, we'll just say so moved.
Got it.
We have a second?
I'll get the terminology
Second.
down.
Okay,
I'm barely getting it, okay, so
Yeah.
I'm definitely not grading it.
any more discussion?
No,
Okay, so the motion to approve staff recommendation with the increased fine of 7,500 has been approved. Oh, I forgot. All in favor?
I,
Aye.
Any opposed? Okay, now it passes.
All right, investigative matter H is complaint number 2026-588. On April 26, 2025, the Broomfield County, Colorado Sheriff Department took the respondent into custody following a sexual assault incident at her residence. On May 1st, 2025, the Broomfield County, Colorado District Attorney filed a complaint that charged the complainant with 2 counts related to sexual assault. On February 19th, 2026, the respondent pled guilty to those 2 counts of sexual assault, assault in the second degree, an F4 felony, 18.3203 CRS, and criminal attempt to commit sexual assault, F5 felony, 18.3402 and 18.2101 CRS. On March 1st, 2026, the respondent filed a self-report complaint to inform the commission of the guilty pleas. The respondent returned to the Broomfield County Court on April 30th, 2026 for sentencing. The possible violation is 1210-217-1N. Disciplinary recommendation is revocation, final agency order, public censure, and the max fine of $2,500. And investigator Levy's on the line if you have any questions.
Okay, motion? Anyone?
We'll move to accept staff recommendation.
Second? Anyone?
I'll second.
Any discussion?
Did the respondent receive jail time in this as well?
60 days, I believe.
Okay.
Yeah, I mean, it's a violent crime. I mean, I think the discipline's appropriate. Any other discussion about it? Okay, so all in favor?
Aye.
Any opposed? Okay, so the motion to accept staff recommendation passes.
Right.
I do have an ask before we jump into the next file. Is it possible to take a 5-minute bio break?
You can have more than 5 minutes on them if you would like.
I appreciate it.
Yeah.
Should we do 10 minutes?
Yeah, because we have quite a few, so yeah.
Because the coffee is kicking in.
Okay,
Thank you.
thank you.
company name not licensed with the division without consent of her employing broker or brokerage. The respondent didn't have any written and executed property management agreements with their owners. The respondent didn't provide written brokerage disclosures to owners and tenants and used non-attorney drafted leases. The respondent utilized bank accounts to hold money belonging to others, which are not fiduciary and don't include the word trust or escrow. The respondent held rental funds and security deposits in the same account. The respondent failed to notify the complainants of non-paying tenants and instead used her personal funds to pay owner rental proceeds. In complaint 2024-1925, the respondent failed to account for tenant deposits and housing assistance funds she received. In complaint 2025-1177, the complainant incurred legal fees in terminating services with the respondent and evicting the non-paying tenant. The respondent didn't reconcile the accounts and she transferred client funds between her personal accounts as needed, totaling approximately $28,000 net. It is unclear if the respondent owes the complainants or any other clients or tenants money. Possible violations include 12-10-2171G, 12-10-2171H, 12-10-2171I, 12-10-2171M, 12-10-2171Q, 12-10-2171T, and 12-10-2171W. Possible rule violations include 5.2, 5.3, 5.5, 5.9, 5.10, 5.14, 5.15, 6.2, 6.5, 610A2, and 614C, and 7.1. Recommended disciplinary action includes final agency order, public censure, revocation, and a $45,000 fine. And investigator Marcy Rivera and myself are here to answer any questions you may have.
Do we have a motion? Thank you, by the way.
Motion to approve.
I'll second.
Okay, any discussion?
I'm curious why, personal funds were used to pay. Is there an explanation for that?
I believe, and Marcy can step in if I'm incorrect in this, but I believe that the respondent was trying to cover up the fact that the tenant was not paying their rent, and due to the kind of, I believe, family relationships and the personal relationships and how she obtained these clients, if there was I think like a sense of pride and not wanting them to know that this was happening, as well as the respondent's spouse.
Yeah, she said she didn't want to look bad in front of her husband.
I think some of my notes are along those lines, really. It's just, she was not being paid the rent. And so she tried to pay those out of her personal funds. I don't think she had malintent, but based on the previous steps, where unworthiness and incompetency came up, in at least 3 complaints, I'm concerned that this is an ongoing issue. I don't think it's resolvable with CE and oversight even, on the decision-making that has gone on. And so that's why I'm in favor of this.
Yeah, I would agree. I mean, I don't think she's in compliance with just about anything. Just across the board.
Yeah.
I mean, she's definitely not qualified to be doing private management.
Yeah, there's 7, I think I counted this right, at least 7 statute violations and 12 rule violations. That's significant. It's literally just someone not doing any part of the job.
No.
Like no requirements are happening in this scenario. So I do think that revocation
Oh, yeah.
is probably the best course of action. This individual did mention, that she's no longer doing property management and that they want to continue to do real estate sales. Obviously, I would be concerned with the level of, or the lack thereof of responsibility here, this individual maintaining even a license to do sales. So I think this is appropriate. And
I have a question on it. I believe it said that when this was, does she still have a property under contract right now? Or has that listing closed? Because I believe there was one that was under contract.
I don't have the answer to that. I'm not sure, Mark.
She does not.
Okay. I was just curious about that file.
I don't know if we've received any update from her on that. Marcy, do you have anything to add on that?
So what I have is that
Yes, we can't hear.
Oh, we can't hear you. Hold on one second.
We try that, Marcy?
Oh, I can, okay.
Well, we can't hear you, Marcy.
You can't.
Coming in, but really low.
On her microphone.
No, she's not muted. You can hear it. It's
You
just
can
not-
hear.
Can you hear me now?
There we go.
Sorry. Too loud.
You're quite all right. Go ahead. Thank you.
Okay. So the question was she doing, or does she currently have any active property management properties?
I think she said she wasn't doing any more property management. She quit doing that, but I recall reading that she had a current, a current contract, property under contract.
Okay, are you talking about sales?
Yeah.
Yes.
So at that time, she did. I do not know if it closed.
Okay, I just didn't know if she still has an active list, an active contract.
Okay. Well, there's a process that has to happen anyway.
Okay.
Autumn, did you have any notes or anything? And if not, we'll just.
I agreed with staff recommendation.
Okay. All right, well, all in favor of staff recommendation?
Aye.
Opposed? No, the motion passes to accept the staff recommended discipline.
Okay, your next matter is investigative matter J. There are multiple complaints tied to this one as well. The first is 2024-2288. Second is 2025-611, and your third is 2025-633. The division received the respective complaints from the complainants, all stating the respondent was hired to manage their rental properties and failed to remit rental proceeds. The complainants allege that the respondent failed to return security deposits, failed to respond to complainant communication attempts. The complainants allege that the respondent allowed her husband for property management and real estate duties without a license. The complainants all sent termination demand letters to the respondent terminating management services and demanding capacity funds. Respondent failed to respond to all three complaints. Subpoenaed bank records showed that the respective tenants' rental payments were made to the respondent but were not paid to the complainants. Bank records show that the respondent used 2 bank accounts to hold rental income and commingled funds amongst 4 other accounts. The respondent failed to hold trust funds and trust accounts or label the accounts holding funds of others. The bank records also show that the respondent used approximately $34,439.16 of trust funds for personal expenditures. The bank accounts have been closed by the respondent. It's unclear where the money was transferred to. It also doesn't appear that the respondent had a designated account for holding security deposits, as those funds appear to have been commingled with rents. The respondent has allowed her license to expire as of February 1st, 2026, and has an unsigned final agency order with revocation for previous investigations with similar findings. Possible violations include 12-10-217-1H, 12-10-217-1I, 12-10-217-1M, 12-10-217-1Q, 12-10-217-1R, 12-10-217-1W, and possible rule violations include 5.2, 5.5, 5.9, 5.10, 6.1, 6.2, 6.3, 6.5, 6.25, and 7.1. Recommended disciplinary action includes final agency order, public censure, revocation, $37,000 500 fine or max fines, and a direct referral to the Attorney General. And again, Investigator Marcy Rivera and myself are here to answer any questions.
Thank you very much. Do we have a motion?
Motion to accept staff recommendation.
Second.
All right, any discussion?
We've seen this respondent within the last, I don't know, year, because that's how long I've been on. So I know that. And I think we probably then, I think they mentioned we, motion for revocation then, yeah.
That's correct.
And her license expired when?
It expired effective February 1st, 2026, so she did not renew it.
Okay.
Renewal period at the end of the year.
Are we still, do we know if we're still expecting any more coming from her?
We do not have any other pending
Okay.
complaints that I'm aware of or investigations.
There's a question of mine with her license expiring out. Does that change anything that we do as far as the process for? Okay,
No, she's got a 3-year reinstatement period, so that gives you jurisdiction to take action against her.
okay. Thank you.
I guess in my question with that, because this is unique in that she's already been revoked.
She hasn't, she has not agreed to the,
Well, okay, so that's the piece maybe I was trying to understand. So she did not agree to that. Therefore, did I read correctly and I may be mixing things up? I can look if I need to. Isn't this person still practicing in some way, shape, or form? Or what, or did it stop after her license expired?
I do not know if we have all the information to say. I don't believe she's communicated with us much during the investigation, so the extent of the respondent's activity, we're just unsure.
And so this would just stack on top of the other one.
Correct.
Okay.
And then when it's expired, it's still coming up and the search as revoked, not expired. How does that work?
So currently, if you search her, it's just gonna say expired.
Okay.
The whole reason to do the direct referral to the AG is they've already got her other case. And so Penny's not gonna try to resolve this one. It's just gonna go straight over. They can file a notice of charges and start the administrative hearing process so that we're still within that 3-year reinstatement period. Once it goes through the whole process and there's an initial decision rendered and then finally a final agency order, then whatever the outcome is, it will reflect in our licensing system.
Got it. Okay, thank you for that clarification.
Yeah, my notes say refer again to the AG's office.
Mhm.
And to answer one of your previous questions, about her activity, allegedly, I think this person is no longer residing in the state, but I'm not certain of that.
Which means they could get licensed in another state right now because it just shows expired. Technically,
Right.
Mm.
If that state had similar laws to Colorado, there wouldn't be anything to report yet because they haven't agreed to anything here, but if that state has similar laws to Colorado, if they were to agree or something does become final for their license here in Colorado, I would imagine that would trigger a reporting requirement in that state.
Okay. Well, with all that said, does anyone have any more discussion?
No, the max fines means that's the max, right? Correct. Yeah.
Autumn?
No, that's.
I don't want to leave you out here.
No, you're good. I appreciate it. I agree with staff recommendations, especially after everything that we've discussed.
Okay. Well, all in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries.
For the new commissioner, I might just add that sometimes you'll see max fines there, and when we're seeking revocation, it is max fines.
Mhm.
And every once in a while, when it is filed with the courts, with the attorney general, there may be a shift or a change in some of the violations that are actually charged. And the direction is, even if those shift, you still want to seek maximum fines.
Mhm.
So if a charge were to drop, we would have to drop it down, or if a charge were added, we could go up to.
Okay,
So that's why you'll see that
yeah,
terminology there sometimes.
okay.
Right. Thank you.
Next is investigative matter K. This is directly related to, investigative matter J that you just heard. This is complaint number 2025-1377. On July 29, 2025, the division opened the complaint against the respondent on behalf of the Real Estate Commission in relation to 5 other complaint and get investigations filed against the respondent's spouse. These investigations appear to indicate that the respondent has been performing real estate activities without a license. The respondent did not provide a response to the complaint or cooperate with the investigation. Possible violations include 12-10-202, and recommended disciplinary action includes an injunction or a cease and desist with a direct referral to the AG. And again, myself and Investigator Marcy and the sheriff can answer any questions you have.
Thank you, thank you. Do we have a motion?
Motion to accept staff recommendations.
Second?
Second.
Yeah. Okay, and now, discussion. I just have a question, because this has also come up. So do we have any information as to the original referral, on this person?
So this is your first
Was this-
case or referral for this
Oh,
individual.
I thought the other one was on there too. Okay,
And I believe this case was opened at the commission's request when you heard the original case.
okay. It just sounded familiar, so I thought we
Yeah.
had already referred it. Okay, okay, and that answers that question. Any other discussion? All in favor?
Aye.
Aye.
All right, aye. Any opposed? And therefore, motion passes to, yeah, motion carries.
Investigative matter M is complaint number 2026-621. On November 26th of 2025, the respondent pled guilty to 18-3-2041A, assault 3, no reckless cause injury. It's a class 1 misdemeanor. The respondent was ordered to complete 18 months of supervised probation and pay $3,830. There is an outstanding balance of $1,293.50. Possible violations include 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with criminal probation. And Investigator Peters can answer any questions you might have.
Thank you. Would anyone like to make a motion?
Motion to approve staff recommendations.
We have a second?
I'll second.
All right, time for discussion. I didn't take issue with the recommendation. I thought it was sufficient. Any other commentary on that?
I agree.
Okay.
I
All right.
just had failure to report incident, so agree with it, so.
Okay. Well, if there's no other discussion, all in favor?
Aye.
Any opposed? All right, motion passed.
Great. Our next is investigative matter N, and N and O are kind of counterparts to each other as well. But for investigative matter N, this is complaint number 2025-343. On February 21st, 2025, the division received a complaint from the complainant stating the respondent, while acting in the capacity as a county commissioner, failed to disclose her affiliation with the brokerage that was representing a potential seller of land in the county. The complainant stated the respondent misrepresented her license level to the public. The respondent acknowledged through the investigation that she failed to disclose in writing her affiliation with the brokerage while acting in a public office capacity. The respondent asserts she received legal guidance from the county attorney who had informed her that there was no conflict of interest because she was not receiving any financial benefit from the transaction prior to her brokerage colleague presenting to the Board of County Commissioners. The respondent provided two separate affidavits where she states in part that she is affiliated with the brokerage from the complaint as an independent contractor. The respondent affirms that future interaction, she will disclose her license status and disclose where she gains her license. Possible violations include 12-10-2171M and Rule 6.17. And recommended disciplinary action includes diversion and $500 fine, coursework in brokerage relationships, and coursework in ethics. And again, myself, our investigator, Marcy Rivera, can answer any questions you may have.
Thank you very much. Does anyone want to make a motion on this? And I'll just say, like, a motion can be whatever, it doesn't have to be. Motion can be whatever.
I'll move to accept.
Okay, so the motion on the table is to accept. Do we have a second? And you can second if you want discussion. or another motion?
I'll second. Just so we can discuss it.
Okay. All right, this is probably gonna prompt some discussion, so I'll let you start. I could tell you.
Okay. This is one where I felt like this should be thrown out. I'll start with that, because she was acting in the capacity of a commissioner in her public duties. She was not as a licensee in the transaction at all. The county attorney was doing all of the review. There was no monetary gain to be made. The complaint was her opponent in the election for the county commissioner seat and lost. It sounds like the complaint was running a campaign to get this woman recalled. It's problematic. Seemed like it was more of a personal and political attack versus real estate related issue. I don't feel like there were grounds for this one at all.
I wrote a note to myself that says the complainant was reaching, for a complaint. That she was trying to create something. Yeah.
Yeah, I mean, she reached out to her attorney and got bad advice and something too, right? Within the county or?
The respondent? The respondent did, she notified, she reached out
And
to
they
the
said it
county.
wasn't a conflict.
Yeah, the county attorney said that it wasn't a conflict. And everybody knew that she was a licensed, agent. I think the complainant might have been a little bit bitter about something and, was trying to create an issue. I would agree to throw it out.
Yeah.
Autumn?
I'll agree.
So, I have a few notes on this too. I also echo what most of you said. I felt that, number one, I didn't see it as a conflict or bad advice from her attorney because she wasn't a party to the contract. Regarding this, there was an issue of, that came to question about her not disclosing her proper license level because she used the terminology general contractor and self-employed, which the complainant interpreted that as her saying that she works for herself. But in our industry, that's not what that means. You can be a general contractor, because that's typically how you're employed as an agent. And you're still considered self-employed.
I mean, independent.
Independent, sorry. And I said general, sorry, independent contractor, thank you. But that's how we are employed in this industry. For the most part, there are some W-2 brokerages, but most are independent contractors and most are self-employed. And she did disclose that she worked under a brokerage. So I didn't see that as an actual issue because she provided evidence that she did misrepresent that. She also sought the legal advice from the county attorney. And, I mean, if an attorney is telling you, hey, there's no conflict here, I'm gonna lean on that attorney's advice unless somehow it's proven otherwise incorrect. And I feel that she did the right thing there. The attorney didn't see a conflict of interest because she also wasn't a party to the contract. She had no financial benefit. And lastly, I just think she followed protocol and no closing happened. I do echo that there is an underlying issue that it's her opponent that's putting forth these issues. And if they were legitimate issues, we'd obviously have to look at that and rule based on that. But I just don't feel that there was enough evidence to show that there was a true conflict of interest. Now, if she was a party, if she was a listing agent or the buyer's agent on this, that would have been a very obvious conflict. But I think because she was a third party acting in her commissioner role, she didn't have the extra duties, in my opinion, based on how this was presented to us. So I'm in support of the dismissal as well.
Yeah, just for the record, I know that it read that, that property, or it was her brokerage that had that property for, listing, but, she wasn't, I mean, they're the ones that decided, the commission decided not to move forward with that specific property. But I also feel like, being a commissioner, you volunteer your time to do this, and even stating that otherwise, stating that it would be a conflict would discourage other public servants, and I think that we have to also show that don't discourage this other realtors or other agents to step up and be a public servant. I think it's important for us to have public servants that would step up to the commission, and I don't think she did anything wrong. I just had to state that for that specific record. It's important to have those public servants.
And I mean, we can't, like, you're gonna have large companies, especially in a smaller town, you're gonna have companies that, there's always gonna be a company that is going to monopolize, let's say, for example, if you have a big company, you're gonna probably have agents that are working both sides, and because of designated brokers, I just don't see it. I don't see this as a conflict. So motion on the table is to accept, so we need a new motion on the table.
I motion to amend the motion, to go ahead and, withdraw. The right terminology is to dismiss, to dismiss this case.
Do I have a second for dismissal?
Aye.
Okay, and then all in favor? Aye. Any opposed? So motion to dismiss passes.
Next is investigative matter O. This is complaint number 2025-344. On February 21st, 2025, the division received a complaint, and the complaint is stating the respondent, while acting in capacity as the listing agent for a potential seller of land at the county, failed to disclose her brokerage affiliation with the county commissioner. The respondent and county commissioner both paying their real estate licenses at the same brokerage. The respondent stated during the investigation that she does not recall if she disclosed to the public the affiliation. The respondent affirms that future interactions she will disclose any possible conflict of interest. Possible violations include 12-10-2171M and Rule 6.17. Recommended disciplinary action includes diversion, $500 fine, coursework and brokerage relationships, and coursework and ethics. And again, myself and investigator Marcy Rivera are here to answer any questions you may have.
Thank you so much. Do we have a motion? Anyone? Since we have such a small board, I guess I can make a motion too. It's normally that's not the case, but I would like to motion to also dismiss this case.
I would second.
Any seconds? Okay. And let's have discussion about it. The reason I mean, it's connected to the first case. I also don't think that this was a conflict. This individual had we don't even know the relationship. It was an acquaintance or maybe a friendship. I don't know, but it was not, family. It wasn't a ownership interest. It wasn't financial. And I don't know that there
was no harm.
Duty to disclose acquaintance in a transaction like that. Like, oh, I know this person. I don't think there's a duty to disclose that in a transaction, and that is how I understand this to be. So I don't think that there was a violation in regard to conflict of interest, because she knew the commissioner, and that's the extent of it. The commissioner was not a party of the contracts. Those are my notes. Anyone else?
Yeah, I just don't see if there was any harm done to anybody here. Am I missing something?
I think I was a little unclear. They just work for the same brokerage.
Yeah.
That's it. They weren't.
Yeah.
The same company, the same employer, the same brokerage.
They work for the same brokerage, and then the county, the county was considering purchasing
That
that
property,
property,
yeah.
a property that was listed by the same brokerage.
So I don't know. I guess I don't know if you have to disclose that. What do what do the regulations state on that? That's what I was
I
a
mean,
little.
if she had a financial benefit,
Which she didn't.
if she had, if it was family, if that was her
Nope.
family member, then yes.
Nothing.
If there was, what else? I wrote them down. Ownership.
Nope, there
So,
was nothing there.
and that's just based off of Rule 6.17. I don't see a conflict. I'm sorry. So,
Are we missing anything? Can we ask
yeah.
council, are we missing anything, council? So. I motion to dismiss it as well. I mean, I would agree, you two already first and second, I would agree to dismiss that as well.
Autumn, did you have any?
Well, I agree
notes?
with everything you guys are saying.
Okay.
Yeah.
All right, so, the motion on the table is to dismiss. We had a second, all in favor?
Aye.
Any opposed? Motion passes.
Okay, next is investigative matter P. This is audit number X 2025-90. An audit on the respondent was opened when the respondent's brokerage firm is disciplined by the California Department of Real Estate in April 2025 for deficient trust accounting practices. The company is a nationwide property management corporation. The respondent is the Colorado employing broker for this company and manages 19,629 doors in Colorado. He is also the employing broker for this company for 5 other states. The brokerage firm in Colorado has no other licensees. He is also a licensed real estate broker performing commercial real estate transactions in California for a completely different brokerage firm. Division's audit involved the review of almost 36 property management transaction files, 20 trust accounts, company manuals, and organizational charts, amongst other documents. The audit found violations consistent with the California Department of Real Estate investigation and consistent with the 2024 division investigation that resulted in the downgrade of the then employing broker for this company, the same company. The respondent did correct some of the deficiencies identified in the previous investigations in this audit. However, concerns remain, including the handling of trust accounts, missing, incomplete, and non-compliant 3-year reconciliations, effective reasonable supervision of hundreds of unlicensed property management staff, and missing and non-compliant required disclosures. Possible violations include 12-10-2171F, 12-10-2171H, 12-10-2171M, 12-10-2171Q, 12-10-2171R, and possible rule violations include Rule 5.2, Rule 5.14, Rule 5.16, Rule 5.21, Rule 6.2, Rule 6.3, Rule 6.4, Rule 6.5, and Rule 7.1. Recommended disciplinary action includes final agency order, public censure, $7,500 fine, coursework in brokerage administration, coursework in trust accounts, coursework in property management, a follow-up audit within 3 months, and a license downgrade with high-level supervision. And myself and auditor Jay McLean can answer any questions you may have.
Thank you. Do we have a motion?
Motion to accept staff recommendation.
Second? Second. And let's have some discussion. Continue.
I feel like this respondent just kind of inherited this, I guess, per se. And is still trying to fix what the issues were from the beginning. I think it's kind of hard to oversee that many properties, 19,000, and then still be in 4 other states. Or 19,000 doors, I should say, and still be in 5 other states or 4 other states. I would almost, it brings up a discussion that, can we require them to be only in Colorado if they're gonna, like, there's no way one person can do this many and do it properly where there's not gonna be any violations and oversee that many unlicensed. I mean, I just,
They must have a staff.
though they have a huge staff,
Yeah.
yeah.
It's a big
100.
corporation
Yeah.
and they primarily do multifamily property management.
Okay,
So they mainly utilize unlicensed
yeah,
on-site managers, for property
for
management.
non-real estate, like negotiating.
Do we-
Things like that.
Do we know how, maybe give us a reminder of how long it was from the point of the original issues with the previous manager? And then this one, was it like a year?
I'd say years.
So it's been a while. Okay.
Yeah.
Oh, I think it's appropriate. I really like that on the recommendation, there was the downgrade on the license. I think that is super crucial and important in this situation. So I'm in agreement with the staff recommendation. I think that was an important one. Do we feel coursework?
Well, is there an audit done?
We are recommending a follow-up audit. Now, we typically audit the employee
19,000
broker.
properties audited.
Ah,
Do you have any idea if there are, I mean, were there any complaints for security deposit problems or anything like that?
I don't know off the top of my head. I have to do a little more research, but I do believe that there have been complaints that have been filed against this company, maybe not this individuals, but the company itself.
so how does that work if we do a license downgrade and then we're recommending an audit in 3 months and we only do brokers?
Good question. I think a problem is, if we do a license downgrade, who the new employee broker would be. I mean, typically what we do is we end up opening on the respondent, and then we would open up on the new employee broker as well. And kind of do 2 audits almost at once, verify that our respondent has actually downgraded their license. They're not acting in the capacity of employee broker any longer. So it's kind of, we kind of handle it in that regard, but in drafting this up, we knew that there might be some complications with that, because I think the brokerage firm and the next employee broker would, I think, need a follow-up audit.
So maybe if this is a thought, if there's a downgrade, because it's unfair to the new person coming in.
Yeah, that's what I'm thinking.
Because they're not gonna be able to clean this up in 3 months.
No.
So maybe that follow-up audit, if we're requiring a downgrade, maybe that follow-up audit is pushed out a little bit more. I'm gonna refer to a property manager. I mean, to clean this up, do you 6 months, or is that, I really don't know.
It's hard, I mean, a company of this size, you would think they'd have some pretty good standards in place in order to even manage that many properties in multiple states. That's just Colorado.
Yeah.
So I don't know what kind of systems they have in place, because they can get out of hand really fast if they're not on top of it, but I imagine they've got some system, they just haven't got them in compliance with Colorado laws, or what our requirements are in this state.
Well, and I'm just thinking.
I would hope, I'm guessing though, I don't know.
I just wouldn't want.
But yeah, 3 months would be pretty, I mean, that'd be a short time for him to get anything done, especially if a new person's gonna roll in.
And I believe this respondent has been the employee broker for this company since about December of 2024.
Oh, so it's,
So
so that's
he-
when he
He's
got.
had enough time to kind of clean it up, so that is fair that we're looking at this for him. I'm more concerned about the next person stepping in. I would want them to have enough time to clean up the mess that was left for them, because it would be unfair in 3 months if that audit, he's already downgraded, and then that audit comes back bad, and now we're looking at the current. managing
Absolutely,
broker.
and we, in a situation where we would open up an audit on a new employee broker, we would have that understanding with them. And I think trying to gauge, are they trying to bring things into compliance and correct it or not? And then, it would be presented to y'all accordingly.
Can I ask a question? I was curious if in lieu of instead of the audit in 3 months, push the audit out to 6 months, but validate and verify that a new supervisor has been put in place within 3 months.
That's a good question too. When there's a recommendation to do a license downgrade, how does that process look in terms of time from the point that we make that recommendation to the point that that is effective?
So I think Penny does a good job working with them. Because the goal is not to have however many owners are kind of like left hanging out in the wind while there's this disruption in the licensing. I mean, I think she usually tries to work to make sure that there is a replacement employing broker identified. I think. So with this recommendation, I would suggest, just based on some disciplinary issues that we've seen with other license downgrades, it would also help to clarify if we could put some restriction language in the stipulation that you don't have a new employing broker that steps in, but automatically there's a written delegation of authority back to this person.
Right.
Because we have seen that, and it's not setting anybody up for success. Unfortunately though, for the new employing broker, like, hopefully the company is upfront with them. We have these issues, they need to be fixed, because we do see, particularly in the property management field, where this new employing broker is kind of blindsided and they don't fully understand what they have walked into. And it just starts kind of this ugly pattern of, we're dealing with a new employing broker and persisting issues, and they get disciplined, and then the company finds another, they're kind of like rubes.
Another
Yeah.
goat.
Yeah.
And I'm just wondering, how, is there any way we can potentially get around that? Because, what can we do? Because I can see that immediately, this next broker comes in, they're gonna fail the audit, they're gonna lose their license. I mean, it's just boom, boom.
Just cycling people in.
And they're not gonna know, they're gonna walk in here not having any idea what happens here. So, and not saying that the license downgrade is not necessarily warranted, but I'm just like, do we continue through this for the 3 months with the audit, see what they're able to do? I don't know, but my thought is that next person coming into this, that we are 100% setting them up for failure and potentially exactly what's seeing here, just a different person.
Yeah.
See, I think that's what already happened, even if he had it in a year. We don't know if he had, you know what I mean? We don't know if he knew the extent of what he was just walking into. He's not even in Colorado, he's in California, and says that now what he does is by email or DocuSign.
And then,
So,
just so you know, it's like, once you vote, it's not, it's inactivated, right? There's the process that we follow. So there's gonna be some time, and certainly when we would present it to you, you would have that knowledge that this broker had just, taken over, and then you can take that into your decision. It's not like a revocation, because.
Yeah,
And
I just wouldn't
And
want them
you're-
to be disciplined right away, for sure.
you were asking about this audit, as if the new person was going to be audited and they would fail the audit and then therefore
I was
disciplined.
thinking, yeah.
But this is a sanction, these are terms for this individual.
Yeah.
And as Eddie mentioned, it would be looking at what his activity is, what's he doing? Has he accepted a written delegation to then sort of circumvent this, those kind of things? And so it's not necessarily setting up the next person, but when you take on those responsibilities, you need to do your due diligence and understand what the issues are with the company and then work to clear those. So it's,
I would hope so. I bet very valid points. It's just when you're looking at, 19,000 properties, that person coming in is very different than someone that's doing one.
sure.
So
So,
when it looks like a systemic failure within the company itself.
yeah,
You do have the authority to take the company license.
okay.
I mean, this is gonna be,
Can the employer and broker be put on like a probationary status where in 3 months or 6 months, whatever, certain things need to be straightened out or some progress needs to be demonstrated, and then at that point, you can then decide, does he get a downgrade at that point because nothing's happening? Because chances are, I mean, there's probably a chance, right, if we do downgrade them, they bring someone else in, it's just gonna be someone in name.
Mhm.
And he's gonna continue
Same
to
staff.
do what he's doing, and if he doesn't change it, what has he got to lose now? I guess he could lose his license, but
he's not in Colorado, so he was given this, right? And is now managing this. I guess that's true. If we downgrade it, they're gonna put somebody else in there. He may not have anything else that he's doing in Colorado because he's in California.
well,
And he's got four or five other states that he's dealing with. This might, when we ask for a follow-up or an audit with him, he may not have anything to give us because he'd be like, well, I'm not doing anything in the state of Colorado. So we're giving him a $7,500 fine and he's like, okay, well, I'm done with Colorado.
Yeah, I
I got
mean,
4 other states. So then, but then now we still have it passed to somebody else. So maybe we don't maybe we don't downgrade license and leave it on him and tell him, you know, do an audit in 3 or 6 months.
I
We
think-
can do probation and set milestones
I like
Yeah,
that we
that's
then
what I
hold
think
him
of.
accountable for.
I mean, the threat of losing their license in Colorado could be a huge penalty. I mean, that's a lot of money. that
I
we're
also-
talking about.
Yeah, and I also am intrigued by what you said regarding the company. And maybe it's just due similar to how we did on matter K, where we just asked for there to be an event. Can we do that with the company in Colorado? How does that work?
Irina is,
I have one follow-up and then I'll try to answer your question. The follow-up is the practicality of the way the discipline works. If that person will not be ready or willing to accept his discipline, then status quo continues. So in that situation, you will be doing audit in 3 months appropriately because he is not downgraded. He's just maintaining his status quo when the case is referred to my end of the case. So that's to take into consideration. And then your question was, can we do
Company.
something with the company license? So I think you were referring to matter K.
Matter K, we
There's
recommended it.
significant difference because the K person is unlicensed. The brokerage is, on the other side, is licensed. So you have to go after brokerage like you would go in for a broker license. And it would be separate case.
Right.
And the problem with brokerage is that it's easy to reopen a different entity with a different name.
Is it that, they could do that then? So if, I mean, if the license were pulled, they could just start another company.
Well, and I was just really thinking about doing an investigate, like having the commission on the commission's motion to do an investigation on the company. And
Well, I guess it
the
would be-
actual company, does that, you know what I mean?
Yeah.
Versus, like, we already have the investigation on the managing broker, but because the company is really where the issue is, can we, as a commission, make a motion, you know, our motion, on our own motion to have that company looked at and investigated?
Just to see if there's. what
And
kind of
then, right,
complaints and so forth, what's going on.
I don't know, does that I'm kind of curious from the division, does that make sense?
so I
Or,
think that investigation would be primarily to kind of determine who's making the decisions about how that company is operating.
So he may not be the decision maker on it.
And it,
He's just-
yeah,
they're not
I mean,
doing anything.
it may be corporate policies that he is marching along to, but
Right.
they may not comply with Colorado law. What I might suggest before you go down the road of going after kind of doing an investigation into the company is, so you had discussed possibly doing probation rather than having a new employing broker step in and inherit this mess. So if you kind of explore that option and then set milestones of you have to have this fixed by this date, this fixed by that date. If he's not meeting those milestones, then maybe that's the time to have the discussion about opening up against the company,
Yeah,
and doing something differently.
I like the probationary portion of that, just to at least follow through a little bit more on this one and not potentially have someone else zip right into this and have the same, you know, and again, I know that we're foreshadowing, but let's do that. And how long would we want to do probation on this in lieu of license downgrade?
So to be fair, he's been the employing broker for about, what,
Year and a half?
18 months,
Yeah.
more or less?
Yeah. And it does say that, you know, in my notes, it's just that the information has just been slow in receiving information. So, I mean, he needs to speed that up.
Because a lot of his responses are, there's somebody that handles this.
Yeah.
Yeah.
Somebody else handles this, somebody else handles this. And so he doesn't readily have information at his fingertips because somebody else handles it. His name is just tied to it.
Maybe
But-
instead of going with the traditional, like 3, 6, maybe we do like 4 months. Under
Is it
20
clear
days.
where they're not? I mean, I know there's a list of violations here, but is it clear where the deficiencies are? I mean, since an audit hasn't been done, we don't really know, like.
Well, we did audit
They did
that. We
audit,
did
yeah.
look at,
There was,
we
okay,
looked at transaction files, we looked at trust accounts, we looked at their reconciliations. So
Yeah.
there were, attorney drafted forms, brokerage disclosures. So
Okay.
there were various things that
are compliant.
appeared to be kind of repeat findings or similar findings from the investigation that was done on the previous employee broker.
Okay,
I think highlighting the fact that they're this national chain, they're using folks to do the work that aren't necessarily located here in Colorado. There were some unique accounting procedures that were addressed in the report. And so, yeah, we did audit them. We did look at kind of the wide range of their operations. There appeared to be non-compliance in various areas, and some of that appears to be tied to the fact that they're largely utilizing unlicensed people to do the work and utilizing folks who don't
yeah,
reside in the state to do the license activity.
yeah. Which I don't know if this is even reasonable, but I mean, if they could submit a plan on how they are gonna get compliant and then demonstrate over whatever course of time we think is necessary to show that they're making progress on that.
That's like those milestones that we.
Yeah.
Right.
Yeah, but we need to see a plan on, because, I don't know, it's easy to just say, yeah, well.
But I
4
think
months.
it's more than a plan because they can write a plan. It's activating the plan and
Yeah.
issue,
Well, yeah.
That's what they haven't done.
That 4 months time, whatever,
Does that
show
sound,
how they've made some progress on that, yeah.
does 4 months sound like a reasonable, I'm kind of looking at you all, like, does that sound reasonable if we did a probation?
I think,
Or,
yes,
I would say
I
yes.
would say, yes, this has been open for about a year, so it's not like they haven't had any, notice, right, that we're looking into things. But, yeah, I mean, I think that's reasonable. We can go back in and take a look and.
Since they're operating in multiple states, I mean, every state has different ways of doing things, so I mean, if it's their normal practice to work a month, they've got to be doing this, adjusting their standard operating procedures for every state, so they just haven't gotten it done here.
yeah. And that's what, if the, oh, I'm so sorry.
No, go ahead.
I was gonna say, so if the term is 4 months, then that, how I'm viewing this is 30 days would be a milestone, like every 30 days it's done milestone. Is that what you guys are thinking or no? Because we talked about the milestones, or would the 4 months be the milestone?
Who sets those? I'm
We-
just curious.
we-
We would need you guys to give us
Okay.
direction on that. And so 4 months is a really short period.
That is-
of data.
I was gonna say longer for probation. I would
Probation until compliant with a follow-up audit in 4 months.
Yeah.
That's, yeah.
Gotcha, okay.
I would keep them on probation for a year and then do the audit in
In 4 months.
4 or 5 months. That's what I would think, because we don't know what that's gonna look like in 4 months. But I guess we can always extend probation too,
Can you give us?
because they're not gonna get this resolved
If
in.
that's the case, we could probably keep this 3 months.
Well, if you did a probation until compliant with a follow-up audit in 4 months,
That's,
and then in 4 months, if you see significant improvement,
And
they're not quite compliant yet, maybe the probation is already in place to remain until compliant. And then, perhaps another
I like
audit at
that
that
better.
point till we get to full compliance. I don't know. I'm just-
Yeah,
It would be better, and if you can correct me, but if we know what to look for, so we go in and do the audits versus setting maybe milestones or anything like that. I think it'd be really hard for us.
We don't wanna tie their
Leave it
hands
to
to
the
anything
auditor.
specific
Yeah.
on that one, so.
okay. So then I would motion to keep or to amend the previous motion to,
So we're not gonna downgrade.
yeah, no, I would remove
Just
the
yet. We're
downgrade.
gonna do
but
4
I
months
would-
instead of 3 months, or at this point with the new, what you're saying, 3 months actually would be
You're
fine.
saying probation until compliant
Probation till compliant
Probation until compliant.
with an audit follow-up
in,
3 months. Is that what you said?
We were originally saying within 3 months, yeah.
Yeah, okay.
When we recommend follow-up audits, we obviously try to be understanding and fair of the, what they may have to correct or bring into compliance. So a larger company, for example, having to move, 100 trust accounts to a new
Yeah.
financial institution, we recognize there's gonna be time
Yeah.
involved in that. So
yeah,
we don't want to set them up for failure. That's certainly, it's not something that we try to do. So to everyone's point, though, this person has been an employing broker for around 18 months. This audit has been ongoing for some time.
What time
It's
do you
not a
think you
new
need?
situation to them.
Do you have a timeline you think you would need outside of that 3 months?
I
On top
think,
of that,
I think if you were to say 3 to 6 months, I think that's fair to the individual. And they also have the ability to try to negotiate or settle and counter if they disagree.
So 4 is right in the
Yeah.
middle of that. My next question is more legal. Because what we talked about is saying probation until compliant. Which. And I'm guessing in the language, we would want to put a stop point on that, because when I hear that, just legally, it just sounds like indefinite until compliant, so.
that's just our license status, right?
Yeah, so are we gonna word it so that it's like until compliant in 3 months, 4 months? Like, where's the stopping point of the compliance? Do you see what I'm saying? Like from the more of a legal perspective, just saying until compliant can be indefinite. They could maybe not, well, you said until compliant.
Yeah.
And hey, it's taking me a year to get compliant. I want to put some guardrails on that timeline.
Sure. My suggestion would say it would be tied to satisfactory follow-up audits.
To compliant.
And you do want the language to be clear as well, so that if this is dragging on for years, that enough is enough. This is now a stiff violation.
Yeah,
Yeah.
that's what I'm saying. We just need that firm stopping point. I just don't know legally how to put that language together, so,
Some sort of deadline.
yeah.
Yeah.
I believe you had raised some questions earlier, just in the broader spectrum of like a company this large, like in their operational and that maybe that raises some further questions that needs or discussions that need to be had around how these sort of brokerage firms are. Yeah,
yeah, I like. In my mind, it's just, I can't fathom one person's license being in 5 states and he's got 19,000 just in Colorado. Like. I would like to, and I don't even know if we're able to do this, but. And maybe it's for something that we discuss later. Do we require? If you have over X amount of doors in the state that you need to be licensed, that you need to reside in the state, you need to be in the state instead of in California, how can, is that even possible to do that? I just can't, like, how do you get in compliance when you've got that much that your name is tied onto?
So I think maybe another way to go about this, which is more our normal process, would be you can take the license downgrade out of it and we just go back in within 3 months and do another audit. And then if they're not compliant, we bring it back to you. And you can still order discipline today. And if that's working through, that's what we would normally do.
And the only way that's gonna encourage is if they're paying for it, so fines, or they understand.
At that time, if they're not compliant, then you can, downgrade. I mean, then at that time, it's up to you, depending on what they aren't compliant on. I think we're trying to make decisions on things we don't know, things that will, it's hard to plan around the future.
One more stab at the probation, because I do think that sends a message. If we did probation until completion of the audit, right, would it still be basically the same thing? It's just that their license is on probation, but, depending on how that audit plays out, we're still in the same place that we would be.
Yeah, you could say they're on probation until the audit's completed.
Yeah.
In 3 months.
And then from there, it resets, right? It comes back to us. We decide if that probation, then we decide, okay, do we keep probation? Or do we, downgrade? Is he doing good? Do we reinstate? You know what I mean? We can kind of make that decision after 3 months. Is that something we could do? I like the probation because it's forcing some action. I mean, the downgrade would do the same thing, but based on our discussions, it may cause a little bit more confusion and harm, but than we intend. So the probation would send a message that we are wanting them to pay attention to this.
I just think you need to evaluate, is it practical to expect them to expect him to get everything fixed in 3 months?
Yeah.
That's my thought too. I think an audit to see what they've completed in 3 months, I think would be great. Because do I think that they can get it all done in 3 months? Probably not, but it'd be great if that's his milestone is, what are you gonna, you have to get all this stuff done. What are they gonna get? And then, we look, then they'll be ordered probably another audit because it's a lot to get done.
Well, how
And you
about,
can do multiple audits during the period of probation. I mean, we haven't just done one follow-up audit on a brokerage or a broker that's had significant issues. There's been multiple audits, and I think what we're really looking for when the auditor goes in, when there are those multiple audits, is to see that progress is being made to put the deficiencies into compliance.
Well, guys, and to jump on that, he can use that as a tool through the McMonster company that this is to actually utilize this as a tool to get the information he needs to become into compliance. Because if it sounds like that's so-and-so's department, that's so-and-so's department, well, here's a piece of paper saying that I have to do this in order to maintain compliance, and I need your help to do it.
I do like the probation. So, do we all like, or do we all like the probation option?
it sends a message.
I know I do. How do you feel?
Yeah, I think what are the consequences of not getting there? That's where, right now, we have a fine. And it's pretty low.
So not getting there,
7,500.
now it comes back
But
in
if
front of
they-
us and then we
yeah,
make the
That
decision.
next fine
Yeah.
needs to be significantly higher.
Yeah.
But what is it that they need to achieve in order to not get that fine? Otherwise, what's their motivation? I mean, 7,500 to a company like this is like nothing.
Yeah, I
It's
thought the
like,
same.
it's not even a slap on the wrist.
well, I think it would be a compliant audit.
Yeah.
So, the auditor knows what to go in and look for.
Yeah.
And
We're not directing that.
Yeah.
it would be similar to the issues that we
Yeah.
have now, just.
And I don't know, you guys probably have a better feel for how far off they are for what they need to correct.
Yeah.
I don't know.
And I mean, it's very good to think of the time. I mean, we don't want to go right back in and, they haven't had time to figure anything out, but even if we wanted to go back within 6 months, I mean, you can hire consultants, you could get people into.
Yeah. I was thinking probation for 6 months.
Because
And then 2 audits. But I need the help of you guys that do that because you know more of that process.
You can definitely do multiple audits, and that way, it's the hope is you're seeing build compliance towards compliance, at least in the first one, hopefully fully, and then the second one or multiple ones, just continuing to verify that they're maintaining that. I think there are examples that you have all seen where we've recommended multiple follow-up audits, and then had to bring it back to you
After the first.
before they got, to the second or third one, because there were still what appeared to be significant, violations. So.
And when they're not making improvement, then that's when you can also discuss opening up against the company license.
Yeah.
Now, in this situation was recommended, I believe, as a final agency order. And if we were to do a follow-up audit, and they were to come back as non-compliant with a final agency order, then the next step goes to revocation. But typically, or, when we do follow-up audits, they tend to come with at first a stipulation for diversion. So that way, when they do that follow-up audit, if it's still non-compliant, then the next step is final agency order before you're kind of immediately jumping to revocation because of a non-compliant follow-up audit.
Okay.
This one, I think,
You don't need to, it's just giving you.
yeah, the recommendation, I think behind this has a lot to do with the fact that this company, this isn't the first time this company has, been presented to the commission. Now it just happens to be this individual that's in place of it.
So 6 months is probation, 2 audits.
6 months, I think is good.
Does that sound reasonable from the auditor's perspective?
Yeah, if you want to do probation at 6 months and then do an audit at 3 months.
And then at the end. Okay. Okay, so really, and it still stays final agency order or with, because how does that work with probation in conjunction with that? Is it?
Yeah, it will ultimately be up to what y'all want to decide on this.
I think you can leave it.
Okay. Okay.
Reflects the seriousness, but obviously can
Yeah.
it's your decision, but that's why that recommendation was there.
Okay. So we are gonna put a new motion on the table. Actually, we have a motion, so let's just amend the motion.
Are we leaving the fine the same?
I think so. Just
What do
for
you
this
think?
first.
I think it's fine. I just think the next one somehow needs to be communicated that if we're here again and nothing's been done, the next fine is gonna be significantly higher.
If that were the case, if they were to agree with, what's put in front of them here, the next time if they end up in front of you again, then they're facing revocation because they're gonna have a
Which that's
final
even
agency,
serious.
agency order.
So that's where we would have to switch it to diversion
Okay,
if you don't want them to face revocation the next time.
It's gonna be up to you if you want to care about
And-
that. It's just a recommendation.
Right,
I'll let
there
the
could
attorney
be
speak
also a
first.
situation where that case that you currently discussing is still making its way. If they will not accept the settlement with Fannie, then it will be still in limbo. So, and then it will be again up for your review. And then you, at that point, you'll decide whether you think revocation is warranted. It's not set in stone.
Yeah.
It's just one of the options.
Okay.
yeah, I think that's fine then. I mean, that seems pretty severe. I mean, unless they're egregiously violating things, which doesn't really sound like it. It sounds like they're just not compliant in some areas. As long as they're not like wholesale stealing security deposits. Taking their license away seems pretty severe.
Okay, so, let's do a friendly amendment to the motion. So motion to accept staff recommendation with the following amendments. We will add probation for 6 months. We will have 2 audits within 6 months and remove the license downgrade.
Correct.
Do we have a second?
Second.
All those in favor?
Aye.
Any opposed? The motion passes.
Investigative matter Q is complaint number 2026-162. The complainant alleged that the respondent did not return the security deposit in a timely manner. The investigation found possible license law violations involving the late return of the security deposit, non-production of investigative requested documentation, competency issues, disclosures, standard forms, and advertising brokerage services without an active license. Possible violations are 1210-217-1M, 1210-202, 1210-217-1Q, Rule 5.21, Rule 6.2, Rule 6.5, Rule 6.10, Rule 6.17, and Rule 7.1. Disciplinary recommendations are a final agency order, a fine of $8,000, coursework in trust accounts, and coursework in property management. And Investigator Geske can answer any questions that you might have.
Thank you very much. Do we have a motion?
Motion to approve. Motion to accept staff recommendations.
And do we have so we have a motion. Do you want a second?
Second.
Second.
Okay, because she motioned, so,
Yeah.
okay. I know, we're almost done. So second, okay, and then discussion. I just had a question. This is more of a procedural question. The license is currently expired. This individual did not produce any documents for the investigation. If they decide to try to renew the license, are we able to have something in place? I don't know if it would be a suspension or what, have something in place where that license cannot be renewed until documentations happen? Because that's, I think what was bothersome about this is they didn't provide any of the documents.
I had the same question.
And then they can actually go now, like at some point, and reinstate, and then what?
How long has the license been expired now?
I think it was recent. I have to
I
pull
thought it
it.
was longer, but I don't.
December 20,
25, yeah, it's not that long.
Oh.
Yeah.
Okay.
So technically, you guys can refuse to renew a license or reinstate, but and Irina can kind of guide you on this, but I think you have to have grounds, and it can't be like, well, you've got this other pending case, so we're gonna take away your due process and refuse to allow you to renew and reinstate. So I think basically and usually we'll put a note in the system, like if he reinstates, Penny will be notified or whatever the note is. But I don't think you can, based on a pending case where he hasn't had a chance to actually take it through the hearing process and have his day in court, that you can refuse to reinstate his license.
So right now he could go from expired and activate. While this is still going on, he wouldn't have to pay the fine or do anything like that, but once it goes through.
But they're all,
Yeah,
will be
until-
pursuing the action.
Yeah.
I'll first try to work with them. And then if I can't, then I'll go to the Attorney General's office. So really the expiration doesn't change anything because they have that right of renewal right now.
Yeah, okay.
And we'll monitor their status. We do put notes in there so that if they become active, then it's sort of, I know they're engaging, and sometimes it can help just to get new contact information, those kind of things, but it doesn't really affect the action that we're seeking.
It's the same as if like you revoke an active licensee today. They still get to keep practicing until they either sign that stipulation saying that it's revoked or they go through that whole hearing process.
Sure. Okay. Thank you for answering that question.
Yeah, I had the same question, so it was
Okay.
just double checking.
Okay. Any other discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes. Now, let's see. We're now headed into licensing matters. Does anyone need a bathroom break, stretch? Any of that? Yes, I got a yes. So let's do 5 minutes. Is that okay? 5-minute little stretch,
Right.
get some refill of water or something, and then we'll dive into licensing matters. We don't have that many, so that's good.
We have licensing and then that title.
And then,
Oh,
no, we have AG matter.
Yes.
And audio is up. You're good to go.
All right, we're gonna go ahead and resume with licensing matters.
If I may oh, there's audio. Perfect.
Oh, okay, there we go, sorry. So now we're going to resume with licensing matters.
All right, licensing matter A is complaint number 2026-544. This is a preliminary advisory opinion. In complaint number 2017-1417, following an investigation that showed the applicant attempted to renew his license under false pretenses. The applicant was found to be in violation of 1261-113-1W and 1261-113-1K and was allowed to voluntarily surrender. The stipulation and final agency order were to be treated the same as revocation. Additionally, in complaint number 2017-818, it was discovered that the respondent failed to comply with or maintain proof of compliance with continuing education requirements established by Colorado statutes and commission rules, which requires a minimum of 24 classroom hours of approved real estate continuing education, including a total of 12 hours, 4 hours each course of annual commission update courses. After 9 years away from the real estate industry, the applicant seeks an opinion on whether he can earn his license back. There's no recommendation, and investigator Levy's here to answer any questions.
Okay, thank you very much. And does anyone have a motion?
His fines were paid, it looks like,
A motion first.
oops.
No, that's okay.
Well, there's no recommendation, so you
Oh,
have to have a discussion.
yeah, you're right. Sorry.
So,
Go ahead. His fines were paid.
yes, fines were paid, relinquished license, but it was also incomplete to go in, order with what was going on when that happened, 9 years ago. I would say, in reading his, letters, I would say it was a positive,
Positive opinion.
yeah, positive opinion.
Okay. Erica?
We had the previous violation, and this was a surrender, which is treated the same as a revocation, so this is heavier than some of the stuff that we do on these. I know that you said that he did not intend to mislead or provide false information. That being said, he agreed to the stipulation while not admitting or denying the allegations. My issue with this came up when reading through his letter. It's very obvious that it doesn't identify or explain what happened from his view. So there's nothing for me to like sink my teeth into to weigh. So I was really disappointed, in my opinion, that there was no review, clarity, or really even mention of a specific situation that involved his previous license surrender from his side. So I was just kind of curious, the other commissioners' thoughts on this one. I feel like if the applicant was to move forward, I would recommend being highly transparent in what the specific issues were and I happen, provide letters of recommendation from those that have known him during this time. I just needed more depth to review.
I think he included letters of recommendation within the application. Letter of reference, yeah.
I just didn't feel like there was a lot of transparency there.
Well, I mean, it was 9 years ago. Do we know how old the person was at the time of? It was 2017?
No, I don't think we do.
So if you
Because
can,
this was
we
a,
can look it up.
I mean,
Yeah.
people grow a lot in 9 years.
for me, I don't think that age really matters. Did you have anything?
What was his misrepresentation? I was trying to read through here really quick.
It
Does it
was,
say?
yeah, I wanna say yes.
The letter of recommendation came from the, I believe it's the potential broker.
Doesn't seem like it's ever like fully, I'm just curious.
And I could have missed it, so definitely tell me if I missed it, but
I think that was the one, the letter of reference.
I'm sorry, are you
There's
asking
a
about?
statement of circumstances, but it doesn't say.
There, letter of references, I think there's just the one from the employment broker.
I thought-
Is there more than that?
There is one from the employee broker. It is dated 2017. So he provided that to us with this application or advisory opinion. Just to kind of call your attention to that.
Yeah, because what was the misrepresentation? I thought it was, something with, legal status.
So, yes, it had to do with, on the application, I believe he had marked that he was a US citizen, but he didn't have, at that point, he was dealing with an issue where he was potentially overstaying a visa. So that was the misrepresentation that I think you were asking about in the first matter.
I'm pulling up that letter of reference.
Yeah, 9 years ago.
Yeah, I would.
We need. You have a positive opinion?
Yeah,
There's ones that we do positive, I had learned this too. There's some that there's positive opinion and there's some that we would say we would agree to give them a license, so there's a couple different ones.
So I'm glad you pointed that out because I
Positive or
didn't
negative,
notice that that was
I need
an
to-
old letter.
I just,
that's needs right.
Some of,
We tried to reach out
Denial.
to the employee
yes,
broker
Restrictions.
because this is a
yeah.
strange amount of time that had passed.
There's
They
like
have not
different-
called us back, so I would just take that letter
Yeah.
or whatever it is. It's not somebody right now saying that they're going to.
Yeah, I didn't realize that that was the old, because it didn't have like a date or anything.
Right.
I mean, I see the complaint reference, but I'm just thinking they're referencing that, but not for the sake of like, that kind of changes it for me a little bit. Because my initial was positive opinion, still may be that, but if he hasn't been able to acquire a letter of recommendation, given his past, it is a little concerning that that was put in here from 2017.
Well, I think the reason he did that is because he's been self-employed for the past 9 years as it was a roadside company or whatnot. So he may not have a letter of an industry letter of recommendation. He might be able to get a letter of recommendation regarding moral character from a peer or a friend or even I wouldn't say an employee, but that I think that's something to consider.
I mean, we had, a few letters from him about his character and things that he's learned.
And we can always respond with a positive opinion and ask that he has more recent letters of recommendation as part of his application.
It wouldn't come back to you if you gave a positive opinion now. It would licensing and see his application come in and we would approve the application. So you could give like a negative recommendation now and then say that he should apply again with more letters of recommendation.
Let me ask you this. Because he had, I personally, I think this would only be a bucket you pull out of when it really makes sense. But in this case, because he had previous discipline by the commission, it kind of makes sense to me to do the positive opinion with restriction, right? Like maybe can we do like the probationary period on his license, or we can't do that?
Well, he already goes into a probationary period in that first 2 years when he's going in, so he'd already be under there.
This is just
a
for him,
high level.
Okay.
this is just so that he could consider applying, correct? For his license.
This is, yeah, so this is, he hasn't,
He
paid
hasn't
money
applied.
yet or
Yeah,
anything like that. He just wants your opinion on if he.
Right, if he could.
If he should go take the courses and
Yeah,
do everything to do it
but
again.
again, it won't come back to you if it.
yeah, I mean, the restriction that you were discussing gives you a couple of things that aren't just standard with the period of high level supervision for a new broker. First of all, I don't recall how long he was licensed before the action was taken, and that time could in theory count towards him moving into independent, but with the restriction, then we get the, to know that the employing broker is notified of any previous action. And it gives a little bit more of a sort of, just open book picture for the new employing broker to know. And we look at approving that employing broker, making sure that they don't have, some action themselves that might be problematic. So you often do positive opinions with restrictions.
I like the idea when there's previous discipline with the commission, because it just allows us a little, little bit of security with this licensing.
Can we just, since this was a surrender though, which is treated the same as a revocation. So did that go through like the whole process of like with an ALJ and everything? That it did not, okay.
No, just resolve that with me.
With you, okay.
Yeah, I would like, just not make an official motion, but I would like to make a motion that we do a positive opinion with restriction.
You would work for your team to highlight enough of this case to bring it back in front of the commission? Because I thought that that's the problem, logistically.
Well, if you do, so you're saying if it's a positive
With the
restriction,
restriction,
Right.
yeah.
yeah, then I don't think that would come back to us. It would just licensing with no.
Oh, he's gotta
it
sign
would-
it.
Then it would go to you.
Then it would go to me.
Right.
I would
He's
Yeah,
gotta sign a
have
step.
them
for the
enter into
restriction.
stipulation. And then-
right. They'd apply and then.
But what I think what you were saying is when there is a positive opinion, whether it's restrictions or not, unless there's some new information in the application, you wouldn't see it again.
I don't think we need to. I just think we want that layer there because of the previous discipline. I think overall, I would want this person to be able to have a path to get their license back. It's been 9 years. I think that's a great thing, but I would also like to have an extra layer of protection because there was previous discipline that came from this department, so.
Can
What
we ask him to
restriction do
come?
you want?
I wanted some suggestions.
Like the number of
So-
years.
He was licensed for 3 years before he gave up his license.
And it's from,
And he was
it's because
44 when the discipline happened in 2017. So this is not like a 21-year-old that makes bad life decisions early on with no life experience.
Can we ask him to come back with some of the, what I'm considering filler information that would be helpful, even for another PAO?
So I think you guys have the option. If that's what you'd like, you can say that you're gonna defer it and the investigator can tell them that there's not gonna be a decision made on this until you guys get timely letters of recommendation
Yeah.
or character references.
Yeah, and that's what I'm just missing. It's just the depth of that. I mean, I don't know what happened from his perspective. He's saying, I don't agree to this or deny it. Okay, I still want to know what happened. We have 2017 letter from a broker that said that they would do it, but hasn't responded to the information. I can't get behind this yet, but I'm hearing my fellow commissioners saying that they are potentially open to that, and I could potentially be open to that with the proper documentation.
it was for non-compliance for his CE credits, correct?
No.
That was
it
one of the other
that was one of
stipulations that was part of it,
Yeah.
but
He misrepresented.
His legal status. Those two.
What's the process, since that's not an option, do we just table this for the next, what's the process to do it for.
Or procedurally, I believe you will reach the same results if you will issue a negative opinion right now, stating
Yeah.
on the record that the reason the opinion is negative currently is because you don't have enough information. He did not prove, his character, so to speak, so more information is needed. Therefore, currently you will issue negative, preliminary advisory opinion, but it doesn't stop him from submitting a better package when he is at licensing stage. So I think cleaner to do it that way.
Yeah.
And we can direct him towards the recording.
Okay.
Yeah.
We'll make a motion.
I motion for a negative opinion.
I second. All in favor? Aye.
Aye.
Any opposed? Okay, motion passes to issue a negative opinion, and hopefully this individual will put together better packets and send it back over.
Did you guys vote on that?
Yes.
Okay.
Yes, yes, we did. Motion
Yeah,
passed.
thank you.
That's okay.
Yes, you got it. Okay, so licensing matter B is complaint number 2026-592. This is an application. On April 17th, 2013, the applicant was convicted of a felony negligent homicide in the second degree. The applicant was sentenced to 5 years of probation, a $755 fine, and restitution of $5,172.59. The applicant has completed all terms of probation and has paid the restitution in full. Case is closed. There's no recommendation, and Investigator Quinton is here to answer any questions you may have.
Thank you. Anyone want to start the discussion?
This is, I think it's either a yes or no, so I think you make a motion. Right? Am I
No.
right or wrong?
No, because there's no,
Discuss.
we have to discuss, yeah.
I read over all the letters of discussion or the letters of recommendation. Personal statement, all of that, with all the information, she hasn't been in any other, she hasn't had any other issues. She is licensed now as a, massage therapist. I would say yes.
Me too. Yeah. So just like, it wasn't a DUI or anything.
Reckless driving and,
Yeah, just probably fell asleep or something.
well, she said she looked down
Yeah,
and hit another car coming on and,
unfortunately killed someone.
yeah, 74-year-old man or
Yeah,
something.
in my,
But I think everything that she's been doing, I think,
Okay.
I would say yes.
same reason.
Erica?
Yeah, I thought it was almost 15 years ago. There's no balance due. Probation was completed. No incarceration was ever ordered. The conviction was disclosed. She was taking full responsibility for her actions and had multiple letters of recommendation, and my vote was a yes.
Autumn?
Yeah, I felt like, quite honestly, this could have happened to anybody, and I'm sure that she has punished herself more so than any other possible like people or institutions could punish her. I felt like she's done everything that she needed to do. I read the letters of recommendation, and I give a positive review.
Okay, thank you. And then my perspective was similar. This wasn't from alcohol or substance use or reckless driving or anything like that. It was 13 years ago, and I recommend a positive opinion. So does anyone want a motion?
Motion to approve? Or motion for a
Full motion,
positive?
Yeah.
It's an
Motion for
application, so.
Positive application for approve,
Yeah,
I'll second
positive
that.
opinion on
the application for licensure.
Approved.
Approve.
Okay, and then you second?
Yes.
All right, all in favor?
Aye.
I,
Any opposed? Okay, motion passes.
All right, licensing matter C is complaint number 2026-629. This is an application. On December 4th, 2019, applicant was convicted of child abuse, negligently causing bodily injury, a class 2 misdemeanor. Applicant was sentenced to 12 months deferment probation and a fine of $479.50. The applicant has completed the terms of probation and has $0 balance. No recommendation, and Tabitha's here to answer any questions you may have.
Thank you. Does anyone want to open discussion?
Again, in this one, I read over all the information. I said yes on this one.
Okay.
She's still a licensed nurse. She's followed through. She paid all of her fines. She had, a broker there. I said yes on this one.
Okay. Anyone else?
I said yes as well.
I said yes.
Yeah, it sounds like a bit of a mistake, perhaps.
And I also agree, 7 years since the last incident. She disclosed everything. She provided good supplementary, information. So, anyone want to make a motion for positive opinion on this application?
Motion to accept. Positive opinion.
Application for license approval. Motion to approve.
Motion to approve the application.
Yeah, for license, yeah. Okay, do we have a second?
Second.
And all in favor?
Aye.
Aye.
Any opposed? And motion passes.
Licensing matter D is complaint number 2026-708. This is a preliminary advisory opinion. On March 13th, 2026, the applicant was convicted of a class 5 felony criminal mischief of $5,000 to $20,000. The applicant was sentenced to 24 months deferment probation and a fine of $1,200. The applicant's deferment is ongoing and the fine has been paid in full. No recommendation, and investigator Quintana can answer any questions.
Thank you. Anyone want to open discussion?
Was a denial for me, negative opinion, needs to finish the terms of their probation.
I agreed on that. I said, should wait the 2 years till he's done with his probation.
Tom?
Yeah, I would agree.
And Erica?
I agree. Recommended reapplying following completion of the probation and submission of the documentation.
All right, and we're all on the same page, because that's also what I thought. It's a very new conviction, just happened in March. So I would recommend that individual reapply after the probation is complete. And so does anyone want to make a motion for the negative preliminary advisory opinion?
I'll make the motion.
Okay.
For a negative
Yep, negative preliminary
advisory position.
Yeah, there you go. A second,
I'll second.
all in favor?
Aye.
Aye.
Any opposed? Motion passes.
Right, matter E is an application. This is complaint number 2026-319. On June 22nd, 2018, the applicant was convicted of a felony theft by taking. The applicant was sentenced to 5 years deferment and probation and a fine of $1,500. She was released from probation on February 1st of 2022. No recommendation, and investigator Quintana is here to answer the question.
Thank you. Does anyone want to open discussion? I just noted this happened 8 years ago. All the conviction requirements are, have been completed for a while actually, and I recommend approval.
Yeah, I had that she completed the probation, she paid the fees, there's no balance, no incarceration, it was disclosed on the application. She took full responsibility in her written statement. There were no letters outside of the broker's letter. I was concerned that, something similar could easily be committed in this type of work, but the applicant has demonstrated many items showing rehabilitation and years of effort, and putting that behind her. So I was inclined to offer a positive opinion.
Okay. So does anyone want to make a motion?
Motion
For license, no, approval. For
Motion
license.
for.
A motion to approve the
Motion to
license
approve.
application.
Motion to approve license application.
Second.
Okay, and any discussion? I think I've been missing. All right, all those in favor?
Aye.
Aye.
Any- And motion passes.
Okay, licensing matter F is an application, complaint number 2026-632. On November 21st, 2013, applicant was convicted of felony robbery. The applicant was sentenced to 3 years probation. Probation was revoked. And he was resentenced to a maximum of 120 months in prison and a minimum of 26 months and a fine of $178 with a current balance of $64.64. On November 25th, 2013, the applicant was convicted of a felony forgery. Applicant was sentenced to 3 years probation. Again, probation was revoked. They're resentenced to a max of 120 months in prison, minimum of 26 months with 116 days credit for time served. The applicant was sentenced to $124.57 fine with a current balance of $50.43. No recommendation, and Tabitha can answer any questions.
Thank you. Anyone want to start discussions?
Are those really outstanding balances?
It's not Tabitha said yet. She unmuted that.
Okay. Yeah, from 2013. There's still like $100 out there. Okay, that's interesting.
I said the same thing.
Very small balance, or it's very small.
There too, because I thought that I saw that the balances were paid, but the referral says that there were balances on both
Yeah.
cases. So,
That was a little confusing.
yeah, and that is a decision-making point of mine, for sure on a couple of these, because if the balances are outstanding, I am a no.
Agreed.
I think our balances have to be paid, but because I had conflicting information, I want to double check that. Can we double check that those balances have been paid or not? And it's tough to look at.
Let me look. Yeah,
Thank you, Tab.
we look in cohorts.
Such small.
I think on the report,
That seems
And for such a long
the
time.
report
ago.
says balances
not have paid on this.
are 0.
I'm looking to their one.
Okay, yeah.
Maybe made a mistake on that.
Well, that's, I mean, there's a lot of information.
And that does
so
make
I
it,
get it,
that
yeah.
is a deciding factor, I think,
Yeah.
for all of us.
We may have updated their report in for referral.
Fair enough.
Yeah. Which does happen sometimes, so. I'm gonna have her take a look. 13 of the 13.
Yeah, it's a bit pertinent.
Looks like that exhibit was uploaded after the report was initially submitted, so let me see. That does show 0.
It is 0.
Well,
There's
yeah,
still a
I'm
couple
looking
of
at
them, yeah.
exhibit 13 shows 0. But I'm trying, it only shows 1. A picture of a payment receipt though, so, but you're right, the report does say that. You know, Tabitha? She was looking
I'm
into it.
looking, oh, sorry. I'm looking through the document because he did send something in showing that it says financial statement. That's just his financial statement. And cohorts. Just give me one moment.
If it doesn't, like, coincide with the numbers, because the exhibit, I mean, yeah, the exhibit, I think it's at 120. And allocated.
These are in Colorado, right? Tabitha?
Oh, we can't hear you.
She's muted. Tabitha, you're muted.
Yes, it is Colorado.
Okay.
I'm just trying to, I pulled it up at full courts, but I couldn't, it didn't come up because I didn't have the page, so. Give me one moment.
I'm, I, I think that they are in Nevada, Tabitha, so I'm not sure we're gonna be able to find on courts. But we can.
Okay, sorry, I just pulled up his case. So yeah, it is Nevada. It's Las Vegas. That's the document that he sent in, and then he did send in a receipt.
And he said that they were paid. I
Yeah,
know that we updated the report, okay.
Okay. So the report is
Ernest Grant
correct.
referral,
Okay.
Not updated, correct?
Okay.
Yeah.
But I think that does
Yeah,
make a
sorry
difference.
about that.
So fines are paid.
Fine is paid, yeah.
Okay.
My notes, you know, obviously whenever you see burglary, that's heightens, you know, concern. But in this situation, it happened, the last incident, but I sneeze, but bless you, happened 13 years ago. And he completed all the requirements. The big piece of this is based on his letters. He maintained sobriety since 2013. And I think that's really important. And then he has a very successful business that he's been running that sounds like he's been running that business for quite some time. The business is profiting very well. The business complements this business. So, you know, I think this person deserves an opportunity just based on the fact that they turned some positive corners in the last 13 years. So my recommendation would be an approval.
I have it as a yes as well.
So long as those balances have been paid in full, I'm leaning towards approval.
Me too.
Yeah, I agree. I feel like, everything that I read, he's come a long way, several written letters of recommendation. The statements, you know, he's taking responsibility for everything. It was a long time ago. He was 19 at the time. He just learned a lot. And so if the balances were paid in full, I, was positive for this one for his application.
Okay, anyone want to make a motion for approval for the license application?
Motion to approve the application for licensure. Sure.
Do we have a second?
I'll second.
Any discussion? All those in favor?
Aye.
Aye.
Any opposed? All right, motion passes for approval.
G.
Yeah. Okay, licensing matter G is complaint number 2026-792. This is an application on February 23rd, 2009. The applicant was convicted of robbery, a class 4 felony. The applicant was sentenced to 4 years probation, a fine, and restitution of $3,522. The applicant has completed all terms of probation and has a $0 balance, and the case is closed. No recommendation, and investigator Quintana can answer any questions.
Thank you. And does anyone want to start discussions? My notes was that he was 18 years old at the time. That was 17 years ago. He's 35 now. He hasn't had any other issues in 17 years. It sounds like he just made some bad teenage decisions. And so I am recommending an approval.
I agree.
I agree.
I agree. I have it as a yes as well.
Okay, sounds like we all have it as a yes. Anyone want to make a motion to approve the license application?
Motion to approve application for licensure.
Second?
Second. Oh, you're second.
No, okay, right. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
Okay, licensing matter H is an application. It's complaint number 2026-700. On March 1st, 2007, the applicant was convicted of burglary 2 of a building, a class 4 felony, and theft of $100 to $500, a class 2 misdemeanor. The applicant was sentenced to 90 days in jail, 3 years probation, and a fine of $3,269.68. The applicant was sentenced to pay $437.50 in restitution. Applicant has completed the jail sentence, probation terms, and has paid the fine and restitution in full. The case is closed. On January 30th, 2008, applicant was convicted of obstructing a peace officer, a class 2 misdemeanor. Applicant was sentenced to 21 days in jail, 1 year probation, and a fine of $282. The applicant has completed the jail sentence, probation terms, and has a $0 balance, and the case is closed. On February 25th, 2016, the applicant was sentenced to a class 2 misdemeanor criminal mischief, $300 to $750. The applicant was sentenced to 12 months probation, a fine and restitution in the amount of $601.28. The applicant has completed the jail sentence term, probation, and has a $0 balance. The case is closed. There's no recommendation, and investigator Quinton is here to answer any questions.
Thank you. Does anyone want to start discussions? I will just say, one thing that kind of stuck out for me on this one was a letter in regard to one of the cases. He mentioned like he doesn't remember. And there's just no true like ownership of what happened. It was just like, oh, I don't remember. And it was these people did that. And just, I don't know, that kind of
I have something similar.
rubbed me a certain way. There was just no real ownership, especially because it was a conviction.
It doesn't seem like he takes full responsibility for his actions, but he hasn't had nothing since February of 2016, which is 10 years ago. So taking that into consideration, he had, I'm trying to remember, I didn't write if he had letters of recommendation, but I kind of feel like there was.
So this was like one, it was interesting because there's some negative and there's some positive. He had lots of really good recommendation letters, but then on the negative, even on the other letter, it was mentioned, to the best of my knowledge and understanding, I haven't been charged. Which I don't know, maybe it's just the writing of that, but I'm thinking, to the best of your knowledge and understanding, you haven't been charged. Either you haven't been charged or you have. So that kind of was interesting set of words, but he said, to the best of my knowledge and understanding, I haven't been charged with any other criminal violations, past or pending.
Oh,
And it was in quotes, so it was
that on all of them, I think.
so I don't know, that was just like, it's not that big.
This one, it's a stupid college thing.
I think it's just,
They were probably drunk.
well, he did say in one of the cases that he, I want to say looked off a police officer or
Yeah.
something, and that's how he got that charge.
I'm gonna be honest, I'm not hung up on that at all. It's always just the burglaries just give me a little heightened.
Yeah.
I'm a little more sensitive to those because obviously you're in houses.
Yeah.
That
He
being
has
said.
been-
so that-
Oh, I'm
Oh.
sorry. I
No,
don't
go
mean to
ahead.
interrupt. I apologize. He has been working on his own as an independent contractor in carpentry for the last 19 years, and he does go on to say that he wants to pair his knowledge and experience in construction with his real estate license.
Yep. And the good is he had a lot of recommendation letters,
He's a-
including the managing broker.
And he's
So,
a father now and
brokers
he's
are willing-
married.
are willing to take him on.
Yeah.
So, I mean, even though there was some things I didn't like about his package, overall, because it was 10 years ago, I had a
20.
It's been 10, well,
no 10 since the last.
Yeah, yeah, those cases.
Yeah.
2016 was the last one. It
Yeah.
was it was 2007, and then a year later was the other one. And while he's on probation, that's when he flipped off a police officer and ended up arrested.
Okay.
Yeah.
You know, I mean,
Yeah.
that I think
That
was
one
just
doesn't
young
concern
and,
me.
yeah.
It was, for me, it was more the burglary charge,
Yeah.
but,
It's,
that one actually happened in 07. And then mischief, I don't know.
We didn't get like a really,
That happened in 2016.
yeah,
So bottom line, I mean, even though there's some things about the package I didn't like, I still had it marked as positive, approval. This is application.
I have a yes as well.
Same.
And then Erica.
Yeah, and I was just looking into that statement, because I remember reading that too, and it looked like he copied and pasted that into all three of his written
Okay.
descriptions of each incident, so.
Maybe
somebody
someone told him
probably,
to do
yeah, you
that.
should put this in here, and he did, he put it in there, but.
I think I've seen that in other ones too, though.
It's language from the application.
Yeah,
Yeah,
oh,
okay.
really? Okay, he just copied and pasted that in, so I think that's where that comes from, but it was in there.
Maybe the fact that it's in quotes, it's like,
It's like, I really don't remember anything else, so there you go. But yeah, I have a inclined to say yes, so, okay, great.
does someone want to make a motion to approve the application?
Motion to approve the application.
All right, is there a second?
Second.
Any discussion? All those in favor?
Aye.
Any opposed? So approval motion passes. And then that concludes our licensing matters. All right, next we have the AG matter complaint number. Am I supposed to do this part as the chair?
So you're gonna need to go into executive session.
Okay.
So I'm guessing Irina sent you a script for it.
Mhm.
And when we go into executive session, that means you guys have to leave the room.
Yep.
Because it's the last item on the agenda, and if you're here for CE credit, you don't have to hang around to wait for them. We will give you CE credit.
So you want us just basically sign out at 1:55 then?
Yeah.
Thank you for letting us attend.
Thank you.
Thank
sir.
you.
Thank you.
Thank you so much for your time. It's much appreciated.
Thank you so much.
Thank you for your time today.
We appreciate you all.
Okay, so I'll see you guys in the executive session.
Wait a minute, wait.
Let's
read the script first.
Yeah, no, hold on. Yeah, I'm waiting for everyone to leave.
Oh,
Right.
apologies.
No, that's
You
okay.
can start while we're here.
Okay, I gotta
Just
find
can't
it.
get into business until you're.
Where is it? Here it is. Okay. Sure. All right, so, this is Commissioner, right? Oh, let me change that. This is Commissioner Chair Erica Sanders. This is a Colorado Real Estate Commission meeting being conducted June 2nd, 2026, and the time is now 1:58 p.m. I move that the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6, 4023A2 to discuss confidential information pursuant to CRS 24-6, 4023A3. The purpose of this executive session, confer with counsel to receive legal advice on specific legal questions regarding the following agenda items. Attorney General Matter A, complaint number 25-1167, 5G? Can't read my writing, 5G, counteroffer. Is there a is SG? Okay, thank you. I couldn't read my own writing. SG. counteroffer, so I make that correction. Following agenda items, Attorney General Matter A, complaint number 2025-1167 SG counteroffer. Is there a second?
Second.
All in favor?
Aye.
We have 5 in favor.
And
Five
I'm
votes.
sorry to interrupt really quickly. I don't have a link to get to executive session, so if somebody can send that to me, I'd appreciate it.
Does she have to?
Yes, let me resend it. Okay, hopefully you have it there.
Okay,
Or-
appreciate you doing that. I did a search for it. Normally I save everything. I just didn't see it. There we go. I got it. Thank you.
Okay. So there are 5 votes in favor. We will now enter into executive session. is 2:08. We have concluded executive session and will be inviting the public to return and ending the recording of this executive session.
And you are back on the record publicly.
Okay. With regard to complaint number 2025-1167 SG counter offer, I motion for the commission to accept the counter proposal as presented, counter offer as presented.
Second.
Any, I have to ask discussion on this one, but,
All in favor?
all in favor?
Aye.
Aye.
Opposed? Okay, motion passes. And that's it, right?
You just need a motion.
So
To
can we
adjourn?
get a motion to adjourn?
I motion to adjourn.
I second that. All in favor?
Aye.
Aye.
Great, we are adjourned.
Thank you, guys.